Buenas and Hafa Day, Guahusi Senador Telo Taitague. This public hearing is called to order, and the time now is 2:05 p.m. Good morning to you all, and those who are watching from home, and to those who are appearing before us, welcome to the People's House. For the record, today is Tuesday, April 29, 2025. This hearing is conducted by myself, Senator Telo Taitague, Chairwoman of the Committee on Economic Investment, Military Buildup, Regional Relations, Technology, Regulatory Affairs, Justice, Election, and Retirement. To comply with the open government law, notices of this hearing was disseminated to all senators and the public at large via email and published on KUAM on Tuesday, April 22nd, 2025, and the second notice, February 25th, 2025. Notice of the hearing was also available on the Guam legislative website and the Government of Guam public portal. I would like to welcome my colleagues who are here joining me today, the Speaker of our House, Speaker Frank Blas, Senator Shelly Calvo, Senator Sean Gumatauta, and Vice Speaker Tony Ada. Thank you, colleagues, for joining us. We have the following bills on the agenda today. However, even though I've been asked, because we have somebody online to testify on one of the bills, and of course the timeline in the mainland is very difficult for them, so I ask that you be patient if your bill was supposed to be heard first. But we're going to be hearing Bill 97-38 first, then we'll go to Bill 33-38, 88-38, and Bill number 75-38, all COR. Before we discuss these bills, I want to set some rules of engagement for everyone to follow during these proceedings. I respectfully ask that we conduct ourselves professionally and respect each other's opinion. When you speak, please make sure you speak into the microphone directly and state your name and title for the record for housekeeping purposes. I ask that the panel members remain in the room for questions for any additional testimony, as may be desired by the senators present at this proceeding. However, if you need to leave, please let me know, and then we'll be able to ask your questions up front, and then you can leave. Questions and testimony shall be confined to the substance of nature of the bill on the agenda. Individuals who do not comply with these rules will be removed from the room and prohibited from further participation. For my colleagues, copies of the legislation and documents received ahead of this hearing can be accessed through the Google Drive link that was emailed to all my colleagues for the public. And for the public, you can find the legislation on the Guam website at guamlegislature.gov. So the first bill on the agenda is Bill 97-38 LS, introduced by Speaker Frank Blas Jr., an act to repeal and reenact Chapter 11 of Title 12, Guam Code Annotated, and to amend 45.3b and 4540 of Chapter 45, Title 8, Guam Code Annotated, relative to the reorganization of the Guam Public Defender Service Corporation to provide effective legal aid and services to persons who are eligible or entitled to counsel under the Organic Act of Guam, the laws of Guam, and the United States Constitution, and to cite this act as the Guam Public Defender Service Corporation Act of 2025. And before I turn this over to the Speaker, I'd like to recognize my Vice Chair, Senator Therese Terlaje. Thank you for joining us. Speaker, you are now recognized.
Thank you very much, Madam Chair. And thank you for all that are here. Chief Justice Robert Torres, thank you for being here, as well as other members that are going to be testifying on this bill. Bill 97-38 LS is actually a bill that we worked with both the Chief Justice and the Judiciary, as well as with the Public Defender Service Corporation, in being able to very basically ensure that our indigent defense basically conforms to what is actually law and constitutionally mandated to be able to provide. And what this does basically is it, for lack of a better term, separates the Public Defender Service Corporation into a separate entity that will be able to manage its affairs. I think that I don't want to go into any more detail and allow those that are going to be testifying to provide the meat to the bill that is being proffered and that's being heard here today. I look forward to your testimony as well as your input and insight on how to be able to ensure that this bill basically provides it satisfies the intent and the need to be able to ensure that this service continues to be provided to all individuals as provided by not just the Constitution of the United States, but our Organic Act of Guam as well. So with that, thank you very much, Madam Chair, and I look forward to the testimony.
Thank you, Speaker Blas. At this time, I'd like to recognize our Chief Justice, Chief Justice Robert Torres, who is here with us. Please state your name and title and everything. And you will be going first, sir. Please.
Thank you, Madam Chair. Hafaday, members of the legislature here, Vice Speaker Ada, Senator Calvo, Senator Gumatautau, Speaker Blas, former Speaker Terlaje, also our former chair. Thank you for the opportunity to provide testimony on Bill 9738, introduced by the Speaker and Senator Telo Taitague. I'm Chief Justice Robert Torres, and I'll be talking about the bill that seeks to reorganize the Guam Public Defender Service Corporation to provide effective legal aid and services to persons who are entitled to counsel under the Organic Act of Guam, the laws of Guam, and the U.S. Constitution, and cited as the Guam Public Defender Service Corporation Act of 2025. The Judiciary wholeheartedly supports this legislation and the principle it advances for our justice system. As the Organic Act and the Sixth Amendment of the United States Constitution make clear, when a person's liberty is at stake, the government is required to provide access to legal representation, even if that person cannot afford it. That responsibility has been fulfilled through the Public Defender Service Corporation, the Alternate Public Defender Service Corporation, and the Judiciary has helped fulfill that responsibility through the administration of the Private Attorney Panel. That panel serves as Guam's third tier of representation, stepping in when the public defender or alternate public defender cannot due to conflicts. It has been a critical safety net. But while the Judiciary has worked to fill the gaps with care and integrity, we also recognize that the public trust is strengthened when the defense function operates independently, free from influence or overreach of any one branch of government. Bill 9738 moves us in that direction. It incorporates the recommendations from the Sixth Amendment Center's March 2024 report and lays the groundwork for a more cohesive, accountable, and independent structure, one that aligns with national best practices. In addition to our full support for the bill's goals, we respectfully offer a few recommendations for your consideration based on the input provided by the Judiciary's Private Attorney Panel in a letter sent by Associate Justice F. Philip Carbolito. Their feedback has been important and has been incorporated into the Judiciary's official testimony. While the bill includes appeals, guardian ad litem appointments, and juvenile cases, we will also work with the Committee on Justice to provide necessary technical edits during the markup process. That's a very valuable process, and we will contribute to that with some technical edits. But we believe these recommendations that I'll discuss now will address much of the anticipated impact while keeping the operational decisions with the PDSC and its new governing board that will be consistent with the Sixth Amendment's recommendation. To ensure a smooth transition, we're recommending that the new Board of Trustees of the Guam Public Defender Service Corporation be constituted and that its policies and procedures be adopted at least 90 days before the effective date of October the 1st. So if the board, we're hoping that the legislature will act quickly and perhaps in the May session to address the Bill 9738, which would give the board enough time before the effective date of October 1st to be constituted and work through the transition period. It's not often that you hear people supporting eradication of their positions, but essentially I've served as the chairman of the Public Defender Service Corporation for 9 years. Vice Speaker Ada's spouse was also a member of the Public Service Defender Corporation Board of Trustees during my last tenure as Chief Justice. But it's important that an independent Board of Trustees be constituted for the public defender. And having the board in place with this transitional period will help avoid disruptions in service and provide the corporation time to operationalize its responsibility. The Judiciary will remain committed to assisting the Public Defender Corporation during this transition period as well to help ensure continuity of services. We also wanted to clarify the prohibition on flat fees. The bill's intent is to prohibit flat fees, which are widely criticized by the Sixth Amendment Center and the American Bar Association for discouraging meaningful representation and in fact incentivizing early plea deals. However, the current language in 111109J of the bill may inadvertently be interpreted by some who might not recognize the difference between a flat fee and a fixed fee as prohibiting a form of compensation that exists currently, which is to cap a fee in a particular case. This does not intend to prohibit capped fees, and to remove any ambiguity, we're respectfully recommending that we just add language at the end of the section that says that the provision shall not be construed to prohibit the use of reasonable case type-based compensation caps. A capped fee is different than a flat fee, and this just makes it clear so no one can second guess what that provision means. And finally, we want to recommend amending Section 4540 of Chapter 45, Title 8, the last section of the bill, to make it clear that the Board of Trustees will handle all appointments when the divisions of the Guam Public Defender cannot accept a case due to a conflict of interest. In their review of other jurisdictions, the Sixth Amendment recommended that this fourth tier, if it becomes necessary, remember we have the public defender, the APD, the private attorney panel division, and then this fourth division, which is just now random appointments to members of the Guam Bar Association. But if that fourth tier becomes necessary, the responsibility should be delegated to this independent commission to ensure uniform, independent oversight and the administration of the public defense services. So it makes it clear that the Board of Trustees will be responsible for making those appointments and that they'll receive a reasonable compensation and the expenses to be paid by the Guam Public Defender Service Corporation, subject to appropriation. The idea is that the Board of Trustees will be able to decide how they will handle that fourth tier. They may determine to enter in contractual agreements with members of the Guam Bar to avoid appointments through everyone in the list. They may have specific cases, if they're felony cases, be appointed to a certain attorney who they have an agreement with to handle experienced and difficult felony cases. They may have misdemeanor attorneys, so it may depend on the type of case, but ultimately it will be up to the Board of Trustees and how they have set up their processes for appointment of that fourth tier. In sum, the judiciary views Bill 9738 as a meaningful investment in Guam's legal system and the people it serves. There has been talk for many years about having an independent and indigent defense organization free from influence of any branch of government, and this is definitely a step in the right direction. We commend the Speaker and Senator Taitague for advancing this important reform. We respectfully seek the legislature's full support, and the judiciary stands ready to assist in the bill's implementation. Thank you very much.
Thank you, Chief Justice. At this time, we would like to switch over on Zoom and invite the next testimony. Okay, there she is. We're doing okay. Adati Gul from the Sixth Amendment Center. You are now recognized. Please state your name for the record and title and what agency you're with. Thank you.
My neighbor from 10 Hills in Massachusetts when I lived there. Hi, Aditi.
Can you hear me? Okay.
Hello?
There. Can you hear me? Testing, mic test, 1, 2. We're good?
It's okay. I can kind of hear you. It breaks in and out, but I will do the best I can here.
Okay. We can hear you barely too. Maybe we can turn up the volume here at home. But if you can also turn up your volume as well, because you're coming in kind of, soft. But we'll try and be as quiet as we can so we can hear you. So please, you are now recognized.
Good afternoon. Thank you for the opportunity to address this committee. My name is Aditi Goyal, and I am the Deputy Director of the Sixth Amendment Center, also known as 6AC. 6AC is a national nonpartisan nonprofit organization that provides expert technical assistance to governments on meeting the Sixth Amendment constitutional right to counsel. I have been in public defense for nearly 15 years. Prior to joining 6AC, I was a public defender in Massachusetts, clinical instructor at Harvard Law School, and investigator at the Public Defender Service for the District of Columbia. 6AC was founded in 2013 on 3 very simple principles. The first is we only really go where we are invited. We don't want to write a report that no one in government requested. The second is we never get involved in litigation, such as class actions, individual cases, or amicus briefs. We trust the legislative process, and we believe that policymakers make good decisions when they are armed with good information. And the third and final principle that we operate under is we are truly nonpartisan. So our board and our funding represents all ends of the political spectrum, because every jurisdiction, regardless of politics, must ensure that the Sixth Amendment right to counsel is being met. In March 2024, at the request of the Public Defender Service Corporation, 6AC published a report with findings and recommendations after evaluating public defense services on Guam. We use Sixth Amendment case law and national standards, such as the American Bar Association 10 Principles of a Public Defense Delivery System, as the uniform baseline measure for evaluating public defense services. 6AC's 15-month-long evaluation began in November 2022, and it involved 4 basic components. The first is legal research and analysis. The second is data collection and analysis of extensive amounts of information that was provided by the Supreme Court of Guam, the Superior Court of Guam, the Judicial Council, and PDSC. The third is court observations of 167 proceedings in front of 7 judges and magistrates over 10 days. And finally, a total of 82 interviews of a broad section of stakeholders, including individual judges, magistrates, court clerks, former prosecutors, corrections officers, probation officials, PDSC staff, and private attorneys. I cannot emphasize enough that we were impressed by the many people and the stakeholders we spoke with about their passion, their commitment, and their dedication to ensuring that every indigent person on Guam receives effective public defense services. We remain impressed by the very positive and constructive response by the Guam Judiciary, elected officials, and stakeholders in taking this report seriously, and we truly congratulate you on having come to this point. This legislation that is before this committee addresses all of 6AC's recommendations from the report to ensure that an independent board with equal appointments from all three branches of government has full oversight authority over all public defense services on Guam, as mandated by the U.S. Constitution and the Organic Act Guam. I'm happy to take questions. Thank you.
Thank you so much. At this time, I would like to recognize the Executive Director of the Public Defender's Office Service Corporation. I know I have you down, Annie, as someone who's going to speak, but we'll go ahead and recognize your Executive Director first, and then he can pass the baton to these two beautiful ladies. And please recognize who they are if they're not going to speak, Executive Director. So you are now recognized, sir.
Thank you, Chairperson Taitague. Before I begin, I really want to thank you and the Speaker for introducing this bill. It's historic for our office and also for the indigent clients of Guam. And we hope that, we also appreciate the other senators for showing up to hear this important measure, right? I am Stephen Hattori, the current Executive Director of the Guam Public Defender Service Corporation. PDSC currently consists of 3 divisions: PDSC Criminal, the alternate public defender, and Annie Gill, the managing attorney, is present, and the Civil Law Center. Carol Hinkle-Sanchez is present here as well. Collectively, we represent indigent residents, basically your constituents, in both criminal and civil matters. And we are celebrating our 50th anniversary of PDSC this year. July 10, 1975, we were created. You guys will be invited to our conference. The defense system is currently under the development and supervision of the Judiciary, as it has been since its inception. The Judiciary has assumed sole responsibility for guarding the Sixth Amendment constitutional right to counsel. Our current board is chaired by the Chief Justice of Guam. Our vice chair is the presiding judge of the Superior Court. However, all public officials, whether you're in the judicial, the legislative, or the executive branch, take an oath to uphold the Constitution. So we're hoping that each of the branches now share in this responsibility of protecting the right to counsel for the people of Guam. We've evolved to the point where this office should be co-equally protected and supervised by each of the 3 branches. The draft bill creates a board giving each branch equal responsibility over the protection and development of this important constitutional and organic act right. It will also permit the judiciary to return to being a neutral arbitrator in our adversarial system of justice. I submit this testimony in strong support of Bill number 9738, the Guam Public Defender Service Corporation Act of 2025. This bill represents a critical and long overdue restructuring of Guam's indigent defense system to align with both the constitutional mandate under the Sixth Amendment and the best practice standards outlined in the American Bar Association's revised 10 principles of a public defense delivery system. This bill is a product of the Sixth Amendment Center's comprehensive study on Guam's indigent defense system. As you've learned, the Sixth Amendment Center provides technical assistance to establish and implement public defense systems that meet constitutional muster while promoting public safety and fiscal responsibility. Now, the Sixth Amendment Center's evaluation came up with basically several challenges that were identified. One was a lack of structural independence. Another was funding that was not based on reliable or unstable sources, such as court fines and fees. These do not align with service demand or constitutional requirements. So the Public Defender Service Corporation and alternate public defenders, they've been fully funded by the general fund for years. And we believe they are sufficiently funded. The legislature has done a great job in protecting the right to counsel on behalf of those two offices. We believe it's time for the legislature to also assume the responsibility of fully funding and protecting the constitutional rights for those who fall under the private attorney panel. Another issue identified by the Sixth Amendment Center were inconsistent standards for attorney qualifications, supervision, training, and workload management. They also identified that there needs to be an improvement in data collection. And so this bill was created to address some of these systemic issues. The first one of independence, right? This bill reestablishes the Guam Public Defender Service Corporation as an autonomous body structurally independent from the judiciary, executive, and legislature. The 7-member board will consist of 2 appointees, each from the 3 branches, 2 from the legislature, 2 from the speaker, 2 from the governor, and 2 from the Chief Justice. The 7th member will be a nominee from the Guam Bar President. This diverse appointment of its board members ensures no single branch exerts disproportionate influence. Structural independence is a constitutional safeguard. It ensures that the defense function can zealously represent indigent clients and breeds trust in the system by freeing the defense from institutional pressures that could compromise the adversarial and fair system of justice. The U.S. Supreme Court has long held that the Sixth Amendment guarantees not only the right to a counsel, but the right to effective and conflict-free counsel. National standards, including the ABA's revised 10 principles, emphasize that defense services must be free from judicial, executive, or legislative interference to ensure attorneys can advocate solely in the interests of their clients. When public defenders are supervised or funded by judges, a structural conflict arises. The same branch responsible for ensuring a fair trial also holds sway over the defender's employment, funding, and assignments. Additionally, the report recommends that other board members from the general public with a background in public service be appointed. For example, the law could require that at least 3 members of the board shall be members of the public with demonstrated commitment to ensuring effective legal representation for indigent persons. Public members may also include individuals with experience in community advocacy, social services, civil rights work, or personal experience as a recipient of indigent defense services. Another issue, a way that the bill addresses a concern is the statewide scope and oversight. This corporation will oversee all indigent defense functions, including public defenders, alternate defenders, the Civil Law Center, and the private attorney panels. So we'll have uniform standards and centralized governance. It would also statutorily create the alternate public defender and the Civil Law Center as separate divisions within the corporation, headed by their respective managing attorneys. This law will also allow the board to enact rules and regulations involving minimum standards for attorney qualifications, training, and supervision. And these will be applicable to all indigent legal service providers. I know currently that both our office and APD, we kind of restrict the type of cases new attorneys have. And I think those are the kind of standards that a system-wide board can enforce amongst the entire indigent defense system. Another issue that they identified was resource parity, and this bill addresses it by enabling direct appropriations from the legislature. This bill strengthens funding stability and moves toward parity with prosecutorial and law enforcement resources. The legislature, as I said, has done a great job funding the constitutional rights of our constituents for PDSC and APD. and this bill consolidates that with the entire indigent defense system. And although this bill does not have funding, the cost of consolidating all indigent defenses under an independent board will be included in the PDSC budget that will be subject to a public hearing later this term. And our board earlier today passed a resolution supporting our budget, which we'll be submitting May 1st to the legislature, and that includes a separate funding for the private attorney panel. The private attorney panel deserves to have the same stable and fixed funding source that the legislature has provided to PDSC and APD. The Client Service Trust Fund is dependent on court filing fees and fines. You know, civil filings and traffic tickets and other fines have been decreasing according to the latest citizen-centric report issued by the Judiciary of Guam. So increasing filing fees and fines are the only means of increasing that unstable funding source. It's like robbing Peter to pay Paul. Civil litigants and traffic violators should not be shouldering the cost of protecting this constitutional right. Another issue addressed by the bill is workload control and effective representation. The new board will be authorized to enact rules and regulations regarding caseloads and to hire or contract with appropriate staff. And so the corporation will be structured to provide effective representation, sufficient attorney time, and continuity of counsel. Another issue is the data collection and evaluation. This bill will task PDSC with collecting and analyzing data to support evidence-based policy making and compliance with constitutional mandates. This will lead to greater transparency, as the legislature will know exactly where the appropriated monies are spent. Finally, continuity of operations. This bill also reenacts statutory provisions currently existing for the operations of the Public Defender Service Corporation, the alternate public defender, and the Civil Law Center. I know the Chief Justice also proposed amendments which would continue all current policies and procedures in effect until a full board can decide if they want to change any existing policies. And so we are in support of any amendment that would ensure the continuity of operations. Now, this legislation is not merely administrative reform. It is a reaffirmation of Guam's commitment to constitutional justice. It replaces a fragmented and underfunded system with a unified, accountable, and professional structure capable of delivering quality legal defense services to all eligible individuals. Bill 9738 has also received overwhelming support from the PDSC Board of Trustees, which passed a resolution supporting this bill. As the Chief Justice pointed out, it would result in both the Chief Justice and the presiding stepping down from the committee, and so usually, that's a good sign that, obviously, the merits of the bill are such that they're willing to yield that kind of authority over our system, and I think it's a recognition of both how well our office is doing and also the need, for independence and for the judiciary to take a step back from supervising the indigent defense system. The Guam Bar Association also considered a resolution at our annual meeting last week, and that resolution also passed by acclamation. I attached copies of both of the resolutions to my written testimony, so you could review those as well. So I, along with John Morrison, the Deputy Director who couldn't be here, he's currently off island, Ms. Gail, the Managing Attorney for Alternate Public Defender, Carol Hinkle-Sanchez, our Managing Attorney for the Civil Law Center, and Shane Nata, our Administrative Director, respectfully urge the legislature to pass Bill number 9738 without delay. Doing so will place Guam at the forefront of indigent defense reform in the U.S. territories and send a powerful message about our collective dedication to fairness, justice, and the rule of law. Thank you for your time.
Thank you, Executive Director, for that testimony, and also like to recognize again those who are sitting at the table. Annie Gale, would you like to say anything, or okay?
Yeah. Thank you, Senator Taitague. I just wanted to say APD, Alternate Public Defender, fully supports the efforts of Mr. Hattori as well as the Chief Justice. We've been working on this a long time, and we would just like we're giving full support to it. Thank you, Your Honor. I mean, Senator.
No problem. No problem. And Carol, would you like to say a few things? Say your name and your title too as well. So.
My name's Carol Hinkle-Sanchez. I'm the Managing Attorney of the Civil Law Center. I want to also reiterate everything that was said by both the Chief Justice and the Executive Director, that this brings, it's almost a historic moment. 50 years ago was a historic moment when our senators back then enacted the Public Defender Service Act, providing equal access to justice for criminal and civil indigents on the island. So this is another moment that's going to be historic when we manage to build a system with full independence for the defense system on Guam.
Thank you so much. If there's not anyone else, I have a couple people who've signed the sign-up sheet, but didn't say whether they are going to testify orally. But Chris Botansky, okay. And I think that's it for now. At this time, I'd like to recognize the author of the legislation, Speaker Blas. You're recognized.
Thank you very much, Madam Chair. And Chief Justice, Executive Director Hattori, and ladies, thank you very much for being here. And you know, you're right. I mean, it's been 50 years since we've basically created the opportunity and ensured the opportunity for indigent defense or defense for individuals who won't necessarily have the resources to be able to defend themselves. You know, it's you know, as a government, we are obligated to be able to provide equal and full opportunity for individuals to defend themselves. You know, matter of guilt is a matter of process. It's giving these individuals that right or that ability to be able to defend themselves. And I think that this bill provides, while it continues to provide that out, it affirms our commitment that this is going to occur without any specter, sphere, or anything of interference or influence. And I think that's the main point here. And providing as well our judiciary, you know, that true role of being that mediator, that individual that has to be able to determine the guilt or innocence. And it's not basically on whether or not we have enough money to be able to do this. Our system of democracy provides that all individuals, no matter race, creed, color, financial background, and whatnot, should have the same opportunity and right to be able to defend themselves and to be represented as is with every other person that comes before the courts. So I appreciate that, you know, Mr. Hattori and, you know, ladies, that as we move forward, you've got a monumental task, you know, before you, being able to put this together. And I trust that it you know, it will get done. Chief Justice, you did mention some of the recommendations you had with regards to specific provisions. And can I ask, again, for the purposes, because we don't have a copy of your testimony here, so if, okay.
Written testimony will be submitted as well.
Okay.
With the specific language, and then we have also offered staff to work with staff on some of the technical edits as well in the markup, so.
Okay, I appreciate that.
Yes.
So, other than that, Madam Chair, I'm pretty much satisfied with the testimony being provided and everything, and I look forward to the support of all of my colleagues to be able to move this thing through, okay?
And the key point, at least for me at the onset, was the importance for the transitional period. And that was why we were hoping to get action on the bill immediately, because we're looking at a 10/1 transition date, effective date. And so this would give the new board time to come in and develop before the cutover of October 1st.
And just to provide the assurances, in this time frame, this period, they will still continue to be funded. So this is not a matter of...
No, the
if
judiciary will continue to be responsible for indigent defense through the end of the fiscal year. And so it's just setting up the board. The new board of trustees will basically, end our term as the board once the bill passes. The new board will be constituted, and they'll start working towards the transitional period of October 1st, when the new reconstituted public defender service takes over.
Mr. Hattori, you agree that's sufficient time to be able to, assuming that things move as the Chief Justice would like for it to move?
I mean, it's a monumental task. I know July is our 50th. If we have July to create the new board, we can say goodbye to the old board and welcome the new board at our 50th anniversary conference. But, we have a really good team. The judiciary has a really good team. I think between the two of us, we can make sure it happens on October 1st.
Okay. Same thing? We're all confident? I just want to get that on record so that way we don't come back and say, I need more time.
Yes, my neck is on the line.
And we're not going to leave them hanging. We'll continue to provide the support that they need to make that transition work.
Thank you very much. Thank you very much, Madam Chair.
You're very welcome, Speaker. Vice Speaker Ada, you are recognized.
Thank you, Madam Chair. I don't have any questions. I just wanted to ensure that when hopefully the committee report will be able to be generated and completed as soon as possible so that we can get this on our May session. I know that this is important to the courts and to the public assembly, so hopefully we'll be able to move it and get it voted on, and that way you guys can start processing what you need to do and how you need to go about it.
Thank you, Vice Speaker. It is important, and anything we can do to facilitate that, we will stand ready.
Yeah, definitely, and we'll also work with the committee chair to get the committee on rules to help facilitate this process. Thank you. Thank you, Madam Chair.
You're very welcome, Vice Speaker. Senator Sean Gumatato, you're recognized.
Thank you, Madam Chair, and it's so good to see some of my old friends from the Judiciary of Guam, and let me just say thank you again to all of you for your service to the people of Guam. I just had a couple of questions, Madam Chair, and let me just start with the fiscal note for the bill. The Public Defender Service Corporation informed BBMR that the proposed changes and the fiscal support are crucial in accomplishing the long-term goal of strengthening the access to services for indigent defense mandated by both the Organic Act of Guam and the U.S. Constitution. Madam Chair, for reference, the PDSC was appropriated $8,890,546 in fiscal year 2025. Of that amount, $1,831,079 was allotted to the alternate public defender for its operations, including personnel services during fiscal year 2025. Now, as we look forward, the appropriation from the general fund was provided to PDSC in FY25 for the purpose of funding the Civil Law Center operations, including its personnel services too, and the appropriation was contingent upon lifting of any moratoriums that are currently in effect, with future limitations based upon the capacity and priorities of the Civil Law Center to provide legal services to indigent senior citizens, victims of domestic violence, and veterans. So, Madam Chair, I'll ask the panel, with the amount that's included in the executive budget request for this coming fiscal year, specifically for the alternate public defender, can you, if you can, just tell us a little bit about the reasoning for the increase in the budget over the approved that was put out by the, I guess what you guys had and what the governor had for FY25. Is there any reason for the increase? Should I read it again? 900 and I think it was 900 and, excuse me, yeah, 950,411. Can you talk about the increase?
So is that the executive submission of the budget bill?
Yes.
I think that's just a placeholder. So we submit our budget directly to the legislature, and we'll meet with OFB about it. So I don't think it comes out of the governor's allotted percentage of.
I guess why I'm asking is that, as you know, and I think it's been pretty clear that a lot of what we're about to do over the next couple months is not going to be just about appropriations. It's going to be about policy, and this is what this is trying to help us create. So I'm just wanted to put it on the record for the committee.
And it is an important point. I mean, historically, the executive budget has, when it's made the allocations to the judiciary, to the public defender, has been less than what the normal budgetary amounts requests have been.
Yes, thank you, Chief Justice. Since the enactment of Public Law 3619 in May of 2021, creating the Elder Justice Center within the Public Defender Services Corporation, what information is available regarding the level of federal financial assistance that the Public Defender Service Corporation has been able to obtain to assist our Manamco, and what commitments are we as a local government obligated to deliver on as a condition for receiving this federal support?
I can answer that. So basically, it's been a steady amount from the federal side, which is the DSC. We receive about $226,000. But my understanding from staff that attended the aging conference in Florida just this past week, there may be potential cuts to the HHS federal monies. We don't know that yet, but the fact is there is a possible potential cut since we're seeing it throughout most federal grants that are being provided. Regardless of whether there is, Civil Law Center is locally funded. We're going to continue to maintain representation or services to the elders as a priority in our office. So we will continue to service them through the Civil Law Center.
All right, thank you, Carol. And thank you, Madam Chair, for the time. And again, I'm in full support of this measure. And again, it took 50 years, but here we are. And kudos to all of you. Thank you again.
You're very welcome, Senator Gumatauta. Senator Shelly Calvo, you are recognized.
Have a day, and buenas. Thank you, Madam Chair, and thank you for all your testimonies and for everybody that's here. You know, this is a great bill. Congratulations for the push, and thank you to the Speaker for this bill. You know, this bill mandates systematic data collection, so I don't really have a problem supporting it, and it mandates performance metrics. It improves standards, governance, and oversight of legal and aid services, protecting the constitutional right to counsel under Guam law and the U.S. Constitution. My question, just a few questions. Just looking into long-term funding, even though the bill mandates stable funding, the corporation will still depend on legislative appropriations, correct? Future budget cuts, political disagreements, or economic downturns could threaten funding stability, affecting the corporation's ability to meet its mandates. Beyond initial appropriations, what strategies are being considered to protect the corporation against future funding shortfalls? And will there be any reserve funds or alternative funding mechanisms to ensure stability during economic downturns?
Let me speak first to some of the strategies that were examined for the upcoming fiscal year. And the judiciary's commitment to establishing a stable funding source for indigent defense. For many years, the judiciary administered the court-appointed legal services through funding support from the Judicial Client Services Fund. Over time, the Client Services Fund became the sole source of funding for private attorney panel. It was the Judicial Client Services Fund and the General Fund. But then the Client Services Fund, which was intended, never intended to carry that burden alone, when the legislature enacted it, it was to help bridge the occasional funding gaps for indigent appointments, not to fully fund the system. So that fund also supports a broad range of other services that are mandated by the statute, including language assistance, jury fees, expert fees, law enforcement escort costs, the operations at Erica's house, and counseling services. So what the judiciary has done, though, this year is we have come in and we have deferred our projects. We use strategic planning to identify our budgetary approaches and our budgetary requests. And we have 4 different pillars of our strategic plan for this year. And we have sought to defer some of the projects that we would otherwise have come in to ask for the legislature for funding. We've decided to defer our artificial intelligence projects. We've wanted also our self-represented litigant kiosks, our court TV for all of the different courtrooms. So we have pushed those projects down the road, kicked that can down the road, and come in with a very lean budget for the judiciary, only asking for essentially a status quo budget with no increases, no new positions, so that the legislature would have some flexibility towards funding appropriately indigent defense. So that's the judiciary's commitment to ensuring that the right to counsel when someone's liberty is at stake, required by the Constitution and required for the government to fund. We recognize the importance, but this is an important bill. And that's why we've taken the steps. And when we talked about our budget request for the judiciary this year, we said, look, the legislature, we've got to give them some movement, some flexibility. So let us come in and not ask for any of those increases that we would generally have asked for with our budget. And so you'll see when our budget gets transmitted tomorrow, we're asking for no new positions, no new projects for the judiciary, realizing that indigent defense is paramount and important to fund. So at least from the judiciary, those are the steps we've taken to give you the flexibility that you need to be able to look at funding of indigent defense appropriately.
Thank you so much. That's a really good explanation and support for the record. I have no further questions. It's only that funding because, you know, where everybody has to tighten belts these days, right? But other than that, I will definitely support this bill. This is a great bill, and I am hoping that our speaker, the author, will consider me as one of his co-sponsors for this bill. Thank you.
Thank you, Senator Calvo.
And thank you, Senator Calvo, for your comments. Senator
Thank you, Madam Chair.
Terlaje, you're recognized.
Madam Chair. Thank you to Chief Justice and the attorneys here who are presenting testimony, and all of you are here for this bill as well. So I just wanted to clarify, we all support, I think the whole community supports the independence of the criminal indigent defense and all criminal defense. So the move out of the judiciary, I think is you know, we're supposed to be done a long time ago. We couldn't get a bill from public defender back then, but I'm glad we have one now. So we get to do that. My only questions have to do with some of the logistics of it, as I share some of the concerns that I guess there was a committee in the judiciary that also reviewed the bill and submitted
Private Attorney Panel Commission, yes.
And submitted their recommendations or concerns to you, Chief Justice. So,
yes.
Yeah, I share some of those concerns, but I'm just going to go through some of my questions. So we support the independence. We support that criminal indigent defense is a constitutional right. It's, of course, taxpayers have been funding this for years now, and I think no one does not recognize that that is a responsibility that has to be done. How much has been paid through the judiciary, through the client services fund for indigent defense, for example, this year?
Yeah, it's best if I call our finance councilperson Diane Goodmullen can give us an accurate portrayal. As you know, we increased the hourly rate and some of the caps for indigent defense. We went from $90 to $150. The private attorney panel almost collapsed. We had one person remaining on the private attorney panel. Part of that was the compensation and other issues, and we had to make the adjustments for it. We're still less than what we pay at the federal court on the hourly rate and on the caps, but we're much more competitive than we were previously. Go ahead, Diane.
Thank you, Your Honor, and good afternoon, Senators.
State your name for the record and your position, please.
Thank you. My name is Diane Goodmullen. I am the Finance Administrator of the Judiciary of Guam. And to answer the question, former Speaker Terlaje, in fiscal year 2024, the Judicial Client Services Fund collected $1,459,000, and the total amount paid to our private attorney panel solely for legal services and other reimbursements was $1,573,000.
More than you collected?
That's correct.
Okay, because then that's the cost that transfers to the taxpayers as opposed to, I think Mr. Torre was objecting to traffic violators and civil litigants paying, but we're just transferring it from one Peter to another Peter, if in his words. Instead of robbing Peter to pay Paul, we're really just transferring it from one class to another of taxpayers. So that's 1.5 million. And for the Civil Law Center, how much of, has been used in general fund appropriations on top of the grants that you receive? What is your budget this year?
So we have separate staff that work off the grant. Those are our contracted staff. The remainder of the staff in the office is being billed, using local funds to man the office. I don't have the balance, but I don't have the balance to date. I can provide that if it's needed, but we have been utilizing the local funds to fund our staff.
Yeah, how much?
So are you talking about just for personnel, or are you talking about operations-wise?
Yeah, everything that the taxpayers are paying over and above the grants that the Civil Law Center is receiving.
This budget request is going to be $1,109,000. It was $950,000 last year, I believe, or roughly around that, or $951,000 to just kind of. And the purpose of the increase is going to be because we've included the retirement. It's organic growth. It's a rollover budget, really. It includes the organic growth. It includes the 4% increase in retirement. And it also, the only thing that it's pulling that was federally funded is the rental of our office space, which is about $38,502. So that's our rental space. It was funded through ARPA. That's the only thing that was funded through ARPA was the rental, and that's being absorbed into the local. So that obviously is what's showing that slight about $157,000 increase from last budget's request or last budget's allocation.
Okay, because I remember when it was for the senior citizens contract that they first extended that authority, and it was supposed to be covered by the grant for the senior citizens contract, but it's very much expanded by $1.9 million. Now you're saying
$1,090,000, I think, not 1.9.
Okay.
Yeah.
90.
And I just want to clarify, Senator Terlaje, that basically civil indigent services was previously funded under the public defenders, their local funds. The only reason why you're seeing the separation and that cost outside of the office is because we separated ourselves so we can create a wall and avoid conflicts. So
they were also doing that under grants, right?
No, they weren't. Some of it was, but not a lot. So it was like it was a really small federal grant that they had, which was the STOP grant.
Yes.
But for the most part, they were fully locally funded. They were paid out of the local budget.
Through their public defender.
Through the
work,
public
yeah.
defenders.
Yeah, I remember. Yeah,
Correct.
thank you.
And that's why, I mean, I just want to make it clear that it was never fully federally funded. It was locally funded since its inception 50 years ago.
No, but when they expanded, yeah.
When they expanded.
But you're talking about 50 years ago, then it was put on hold. Then they operated with grants for the civil portions, and the rest was criminal indigent defense. And then they came in and got authority to expand for senior citizens services. They said they would be able to sustain themselves on grants, but they were not. So we've increased the budget over the years. So I'm just wanting to put that on the record. So one of the questions I guess I have for the judiciary is, so it was pointed out by the committee that the financial management division that's currently handling the payments to the lawyers that the court appoints is currently very efficient, but it requires labor-intensive work, layers of review and accounting that ensures appropriate and timely compensation of appointed attorneys, and they were concerned whether the public defender would be able to handle that transition. Is there any way that the court could continue to handle those operations and not have just the money and the payments to the lawyers versus if, you know?
I think that for the autonomy purposes, I think it's best that the independent agency do it. I'm more than comfortable that the PDSC will be able to handle the financial aspects of it. Included, they're looking for an ASO and an accounting technician that will help them fulfill those obligations. And, you know, we have, generally lawyers bill between 60 to 120 days after performance of the services. So we are going to be responsible for paying all the bills up through September 30th before the cut on 10/1. So we are actually going to be handling all of the financial arrangements almost through the end of the year. And so PDSC will be able to be up and running their operations to be able to do that. The judiciary is going to help them understand the process, how it's worked in the past. And it's going to give the autonomous board the opportunity to determine how they want to structure the private attorney panel going forward. And that's really, I think, the most important thing. So I'm pretty confident that, you know, it's not rocket science we're talking about there, that they'll be able to handle it.
Well, this was a concern brought up by the committee
I
that
understand.
I am repeating. Yes.
And obviously they're, you know, I mean, they're concerned because that's money that gets paid to them. They're not going to have to worry for sure. You know, the judiciary is going to handle their payments up through the end of the year. And I think public defender will have the infrastructure set up well in advance for them to be able to manage it going forward.
All right. And then, so that would require additional infrastructure at the public defender, right? And so this is another thing. So it looks to me when reading the bill, you're dividing it into divisions. Every division's having a managing attorney, and that's like 1, 2, 3, plus an overall, I can't remember the title, but the manager, I think, and those types of costs. And it looks like it's going to significantly increase the cost of the current public defender services, even if we added on what was being paid, you know, what's being paid to the client through the client services fund is going directly to lawyers only, nothing to staff or anything else, just to the lawyers, the panel.
The budget that was passed today or recommended to the legislature to evaluate for the total indigent defense package was $1.6 million.
Are you talking about for FY26?
For 2026, the recommendation was 1.6. And that will be sufficient to fund the entire private attorney panel division.
All right, what do you mean? What recommendation? For public defender?
From the public defender.
1.6 total?
for the PAP portion. What is the private attorney panel now?
Oh,
Yeah,
right. They have the same amount that's being covered under the Client Services Trust Fund today,
correct.
right? Or 1.5 plus a little bit more.
Yeah, correct.
That's what I mean. So that's one cost that will be increasing on the taxpayer side. There's also another cost for the admin, as you call it, the infrastructure that public defender is going to need.
But that's included in
right?
the 1.6. The 2 positions are included in that.
So you're going for status quo for the attorneys, plus 2 positions. But have we received that?
No.
Okay, so you're talking about what they're working on.
It'll be submitted
Okay.
on May 1st.
All right.
Correct.
And then, can you just clarify, Chief Justice, who will be determining, if this bill passes, who will be determining that a client is indigent? And are you going to still be appointing or referring them because you have found them to be indigent, that they go there, or how do you foresee that to be working?
The determination of indigency will be based on the standards that exist now for purposes of indigent defense. It may be modified in the future, but there is standards for determining when a person qualifies. And if that person qualifies, then he's entitled to constitutional representation.
Who will be making that determination?
The determination will be made by the independent board.
Okay, because that's another one of the points that was brought up in the letter, and it talks about it is the judiciary's sole responsibility, which includes appointing legal counsel for indigent defense in criminal cases. And that's why I wanted to clarify if the appointments will be continue to be made, like you appoint public defender, and then they decide among themselves whether it goes to public defender, alternate public defender, or where it has to go, or to the client panel.
I think the whole intent of the bill is to take the judiciary out of the business of indigent defense and the indigent.
So how would a client then, Steve, how do you foresee the clients actually getting to you if they're going to court first? They're mandated to go to court.
So typically at the magistrate hearing, they'll find out if they meet the income guidelines, and then we would automatically get appointed.
You get appointed, right?
Yeah.
So how do you foresee it to be working?
Yeah, it should pretty much work that same way.
You would be appointed by the judiciary, by the judge, right? So I think the judge still has to make an appointment. And so I think that's the question is, so if that was the case, then the judge should be making the determination as to indigency. That was one of those technical things that was brought up in the letter, and I'm hoping you guys have a solution for that.
I mean, so currently they use guidelines that the Public Defender Board passes and recommends. And so I think there should always be a procedure where if an individual disagrees with our board, that they can appeal it to the court and say, notwithstanding those guidelines, I believe I still should have an attorney. So, but, there will be procedures set up to, develop, to make that clear, right?
Well, the bill is clear that the corporation has to accept. The bill is clear that the corporation has to accept all appointments from the courts to provide legal services unless they have a conflict of interest. So at the beginning, yes, we make the appointment, but then each of the respective divisions, it'll go from the PDSC down to the APD to the PAP. If all 4 are conflicted, ultimately the board will decide the last tier how that appointment will work.
Yeah, so my only issue is I think there might be some language that needs to be tweaked to make sure there's no inconsistent language in the bill from where we all agree that it's the judges who are actually appointing to go to the public defender, and then the new process will take place. And when the court makes its appointment, how it determines that's going to be up to the court, right?
And I think I think in the bill itself, it also makes clear that the determination of whether a defendant is indigent is at the discretion of the judge before whom the defendant is appearing.
It does at one point, but isn't there another point, Steve, where it says that the commission is going to determine the
guidelines?
Yes.
That's But I mean, if the judge makes a determination that the person doesn't qualify in his discretion on those guidelines, he won't appoint that person.
All right, I just think that we need to make sure that that's clear. And the bill describes that the Public Defender Service Corporation will be autonomous and independent and of any other branch of the government of Guam. It can't really be autonomous because it's not producing its own revenue, right? But it's going to be completely funded by taxpayers except for the parts that are funded by grants, such as the senior legal services contracts with public health. Is the bill cover representation at the appellate level? Okay, did you get a copy? You're on the committee, you were CC'd, the letter from Justice Carbolito representing the PAP Standing Committee. It says they're recommending that language be included to assure appellate jurisdiction?
Oh, I don't have any problems with that. I just assumed that the appellate, it would cover appellate representation like it currently does. So, but if we need to clarify that, we could spell it out.
All right, and then, the rest of the discussion is still that who decides whether they're indigent and who is actually making the appointment. And then, will guardians ad litem be included?
They are.
Will they be included under this new one?
Yes, and those are some of the technical edits that are there.
They're not currently included, right? Only indigent legal representation or the other juvenile representation of attorneys, but the guardian, I guess he's saying the guardians ad litem provision is separate and should be either separately included or not. So these are just things that, there should be a distinct appointment structure for the guardians ad litem and other juvenile proceedings and juvenile delinquency cases. All right, so I also listened in on the informational briefing that the public defender gave to the Guam Bar, and there were some questions brought up about the bill requires members of the board to be lawyers, but does not require them to be licensed in Guam. And I guess they won't be directly familiar with the local legal system, the unique challenges we face, and is this, I didn't hear any recommendation today to make any changes to that. Are you saying, Steve, that this is a benefit to have off-island lawyers on our criminal defense commission?
I think that might be considered one of the best practices now, just so that you have an independent outside disinterested attorney, but who still must protect the right to counsel. But realistically, because of our, the time zone, it's not likely we would get anybody who, isn't already on Guam. But we're not objecting to changing that out.
The bill does allow for attorneys who are not licensed members of the Guam Bar to still sit on the Board of Trustees. And the Guam Bar supported the legislation unanimously. I know there was some discussion. And, whether that comes to fruition or not will depend, but it might be an opportunity to get someone with significant experience in indigent defense who can be an asset, but isn't a member of the Guam Bar.
Are you saying, Steve, that in other jurisdictions they put lawyers from outside of their jurisdictions onto their commissions? From outside of their jurisdictions?
That's correct. And I'm not sure, is it Didi?
Yeah, I was just going to say, Senator Terlaje, let me go ahead and give that question to Ms. Gould, if she's still there from the Sixth Amendment Center.
I am. Thank you for the question. So It's an important one. There's nothing that prohibits, there's nothing in the law or in national standards that prohibit lawyers from outside of the jurisdiction being appointed to and being members of a board. And there also is no one cookie cutter model for how and which kind of appointments should be on the board. And this is particularly beneficial for Guam because during the evaluation, it really became apparently clear that because of Guam's location, it could help from having and feeling less isolated by having the option of having other lawyers who still must abide by the Sixth Amendment law in the US Constitution to present on the board and to be on the board. I think the language of the bill wouldn't make it a requirement, just provides an option for the board to have in the event it's necessary and in the event that it's desired. Currently, this is not something that other jurisdictions have practiced yet. However, it actually has been the cause of some commissions dissolving because they could not find members to actually be on the board because of lawyer shortages and other issues in some of the rural states. So this is actually something where it's lessons learned of what's going on in mainland in some of the states and to at least provide the option for Guam.
All right, thank you. So it has not yet been practiced in other jurisdictions, but I appreciate your testimony. Thank you. I'm all for the data collection because this should all be driven by data. It's very specific what type of data should be collected, and I'm curious whether we actually have this already because they made a kind of a big deal about having to do this, and it's going to be a big burden, but it's to how much time actually required to effectively represent each indigent defendant in each type of case, how many cases each defense system attorney is handling in a given year, what other workload responsibilities each defense system attorney has in a given year, and whether each indigent defense system attorney is working with sufficient support to allow them to dedicate adequate time to each defendant. So it's great if we don't have that yet, that we're going to be collecting that data and reporting that on a regular basis.
And we kind of have that data for APD and PDSC, so we actually kind of have most of that data already for PDSC and APD, and we just want to provide that also for the private attorney panel.
Okay.
We don't want them to be overwhelmed if, if they
Okay,
have too many cases.
so this is something that should already be being done, right? Except for the private attorneys, maybe. All right. And then I thought I also read somewhere in the report that the private attorney panel cannot be managed by the public defender, by the Indigent Defense Commission, yes, but not by the public defender because there would be a conflict. But I mean, but do you see the format as given in the bill to be correct in that regard?
I mean, I have an answer, but maybe Aditi, is she still available?
Okay. Ms. Go, it's Go, right? How do you pronounce it? Go? Did you hear the question? Did you hear the question? Okay.
I did hear the question. Thank you. Yes, Senator, it is typical that there would be a managing attorney within the public defense organization to be providing oversight, fiscal oversight, and there'd be autonomous oversight of the private attorneys. So that is the structure that is recommended.
All right. Not separate, right? They should not be separate. Okay.
That's correct. It should be part of the overarching Public Defender Service Board. That's correct.
All right. I'm just making sure. And then the Chief Justice has recommended 90 days implementation period. I think the committee had recommended 6 months, but they're saying if you're recommending 90 days and they're confident that 90 days is okay, I'm not sure. But one of the things that the committee will have to do, or the commission will have to do is to develop standards, right, as to how you're going to develop conflicts, all of the standards, indigent conflicts, when do you go to this panel versus that panel versus that panel? These standards, have you prepared them already?
I mean, so we already have standards that apply to our office and APD. It would just be a matter of extending them to the private attorney panel. I don't really know what standards they're using.
All right.
But we'll all be on the same standard.
Okay, could I get a copy of that, please?
Oh, sure.
The standards, and then if there's something that the judiciary uses to review billings, I just want to know, like, what categories do they look at to review billings, and who makes that determination whether too many hours are acceptable?
And that's really why an independent commission is kind of better in ways, because the judiciary, they don't really like overseeing the work product of defense attorneys, but these independent commissions, since that's what they end up doing. And so there is a lot of
so I just want to see if the judiciary has their standards already in place, and we can just look at it. Because I'm guessing, as you guys have describing it, that may be adopted or moved over to the public defender, hopefully very similar.
Yeah, I think that would be the recommendation at the onset, but obviously it will be up to the independent commission to determine what they want to do. But, you know, that they look at the standards that are currently adopted and transition over using that as a guide.
So, Senator, we do have a miscellaneous rule adopted by the Supreme Court, and it is available on our website as well to all of our panel members. So it's a miscellaneous rule, and that has the standards relative to what is reimbursable, certain caps based off of the case types, and then service period, and then the hourly rate.
Sorry, okay, thank you. And the last, so these defined workload limits, that's one of the things. Do you have currently defined workload limits?
So I guess the ABA approved new workload limits in, I think it was November of 2023. We haven't actually adopted those or implemented any of them.
So for me, it's the workload limits that you adopt or this commission adopts that's going to really impact the amount. I mean, that means the commission says this is your workload limit. That means you can't handle any more cases. That means we need more lawyers. That means we need more money, right? And so that's our concern, or at least one of my concerns, not all. But just are we able, are you proposing to adopt the ABA? And if you did, what kind of impact is that going to have? Are we going to have to double our fleet of lawyers in the public defender's office to cover those workload limits? To me, that's where the discretion really matters, because, you know, our funds are limited, and I agree criminal indigent defense is a priority, but we're also, you know, losing that pot of money from the judiciary. It's being transferred over to general fund. So, yeah, do you have an estimate of what these defined workload limits might impact budget-wise?
So we actually haven't calculated what they would be, but we could tell you across the nation they are resulting in reduced caseloads. But, you know, obviously we're really would be restricted by the budget that, you know, we're provided. So they're really...
So you think it would work in reverse? You get the budget and then you determine workload?
Well, so, I mean, obviously, like some jurisdictions, they're developing like 5 or 7 year plans to increase the number of attorneys to meet that workload. And, you know, the workload, it's just a recommendation. As long as we can provide, you know, the goal really is to provide effective representation that, you know, is competent, right? And so as long as the workload does not exceed that, then I think, you know, we're fine.
Okay. All right.
We just don't want cases getting reversed because of stuff like that.
Yeah, okay. Fine. Well, yeah, we don't want that either, right? And the discretion has to be, I guess, with the legislature as to the funds that are available. Sure. Did the Sixth Amendment Commission report include any recommendations as to the Civil Law Center Because I didn't see any, only the public defender and the APD. Is that correct?
That's correct. I don't think that was actually part of the report. Maybe
Yeah,
Dee
I didn't
could
see that in
still-
the report. It seems to me it was only Guam that included that in there.
At this, can I ask Ms. Go from the Sixth Amendment to answer that question as to why it was not included into the report?
Yes, absolutely. So the contract in our evaluation is of services that are required under the Sixth Amendment in the U.S. Constitution. To the extent that we touched on the Civil Law Center, it was to discuss how it overarchingly can affect funding of everything or the attorney workloads if there was a crossover of the attorneys, which there really wasn't. So we do not evaluate civil legal services.
All right, I appreciate that. So I guess my point is there's nothing that's in the Sixth Amendment that's requiring that the civil part of the public defender currently being together with the indigent criminal defense part. And we are trying to resolve the indigent criminal defense part. And we are also trying to fund civil work when we can. But I appreciate all your work. So I want to just thank you all for your work on the bill and getting the consensus of the stakeholders, Situs Masi. And thank you, Madam Chair.
You're very welcome, Senator Terlaje.
And if I may just, Senator Terlaje had asked about the National Public Defense Workload Standards. And the current ones that Steve was recommending for felony cases, they average from 286 hours for a sentence of life without parole. Murder cases, 248 hours. Sex crimes, 167. And other high felony cases, 99. So they range from, and then misdemeanor or parole violation cases average 13 and a half hours. So it goes from 13 and a half hours to 286 hours.
Yeah, so my question was more, have we adopted those? Do we exclude clients because we've met those limits or not? But Mr. Torrey assured me that they would not be doing that. They would work with the budget they're given, and they would continue to accept, even if it exceeds those standards. Hopefully not, but if it does, they would continue to work as best they could to manage that, correct?
Yeah, that's correct.
Currently, PD does not have adopted standards where they refuse to accept workload in excess of the recommended hours.
That's why I'm checking, because they said they're going to establish that standard. The commission would, and then it sounds like everybody would have to abide by it. But Situs Masi, thank you, Madam Chair.
You're very welcome.
Madam Chair, I have a quick question for you. I know the bill's 29 pages, and I'm not sure how long the Sixth Amendment Center's report is, but I'm hoping that
72 pages.
Yeah, I'm hoping that they'll, if you'll,
it'll be in the Google Drive.
Report.
Yes.
Well, I mean, to at least they'll go into the report.
Absolutely.
All right, thank you, ma'am.
We'll put it. Yes, in fact, again, I'd like to thank Ms. Go from the Sixth Amendment, who's still online with us, and I know it's probably quite early in the morning over there for you, so I appreciate you hanging in there for it. This is a very important piece of legislation. Like it said, it's long overdue. We want to do it right the first time, and there are some, nothing's perfect at this point, but we're going to do everything we can to make it as perfect as possible, and that's why I'm extending, everyone to discuss this even in depth when it comes to the cost, which there will be a cost, at $1.5 million coming from the service fund, client service fund. Yeah, even I said that, client service fund. This funding, I think it was in the 33rd Guam legislature when they incorporated additional strain on this fund, if I'm not mistaken, to take over language, I think, interpreters for that. So you've added on to what was once 3 to 4 areas in which to cover now. And I'm looking forward to the budget hearing to discuss more of that and how we can fund this area, because there's going to be a startup cost. And we know that the judicial branch want to be independent, have, PDS to be the independent of the judicial branch. But of course, it comes at a cost. And that's something we're going to have to look into. I do just slightly few questions. Most of them were answered that I had. But on page 12 of the legislation that's before us today, my concern, and was brought up earlier, about being a corporation. You can't be a corporation if you're an autonomous agency. You can't abide by that. So I was looking if anyone has any objections to Section 11103, Establishment of Public Defender Service Corporation, in order to provide an effective public legal services to those persons in Guam. There is created a public corporation to be known as Guam Public Defender Service Corp. Period. After that, strike out everything else. So if
I think that I wouldn't have an objection to that. In fact, we were going to actually try to see if we could just, because we would have to get a new EIN number if we change our name, we were hoping to just keep a Public Defender Service Corporation as the name of that entity.
So, okay, so that's a good question with regards to maintaining the same name so that you don't have to change your corporation. Chief Justice, is there any issue with that? Okay, so it's noted, and we will make that change to ensure that and to provide that corporation that it is, a corporation. So, I will get with you as we go through the market meeting. There's a lot of stuff to talk about on the market meeting.
And we do, and most of the PAP committee points were technical edits that we have markups ready for with you, Senator.
Absolutely.
And like I said, the main parts for us were the transition, the fixed fee versus the capped fee, and then clarifying that when you get to that fourth tier, you have an independent appointment system.
Okay. Well, thank you for that. I'd like to thank, who are Aditi. How do you say your name, Steve? Aditi, I did say it right. Okay, Aditi.
That was perfect, yes.
Oh, thank you so much. Again, I appreciate your time that you spent for us. The report, being 72 pages long, was good reading. But there is one question I'd like to ask you, is that have you read the legislation in front of us today?
Yes.
Okay, and is there anything in this legislation that you may have some concerns with, that you've, as a professional and put this together, that found that it didn't work, but yet it's still in here? I mean, Guam is a different character all itself, from compared to the mainland. And just wondering if you see anything in the legislation that we might look at a second time or consider to change or amend.
There is nothing in this legislation that concerns the Sixth Amendment Center, and we do believe that this addresses all of the concerns from the report.
Okay, well, thank you so much for that and for your time as well. And at this time, I'd like to give the closing to the author of the legislation, Speaker Blas. You are now recognized.
Thank you, Madam Chair, and thank you to my colleagues for the questions, and most especially thank you to the panel for being here. Ms. Gill, Ms. Sanchez, Chief Justice, and Mr. Hattori, and ma'am, thank you very much. You're right. This is monumental, but at the same time, what this bill basically provided is an opportunity to get things rolling and to iron out. That's what this public hearing is for, is to iron out a lot of the kinks and every time we put something together that we go back, there's always something that we can make better, and that's what we're doing here. I've got no qualms and no concerns with regards to some of the issues that were brought up and some of the things that we can change out. I think we have enough time to be able to do this. And I look forward to working with the committee and as well as to your staff.
My staff's done a great job, and they'll be working with you very closely and with the chairwoman to make sure that we get everything needed to get the bill ready and submitted and the committee report done.
Okay, well, we are working with a very tight timeline, so we're going to be putting everybody on overtime. Okay.
They're ready.
They apparently know how to get a hold of me. All right, so we'll go ahead and continue to work that way. But thank you very much, and look forward to continuing to work with you, getting enough of the kinks out of it so that it does, when it does hit the floor, it does get the supports necessary to finally move this forward. Thank you, Madam Chair, for not only having this hearing, but for co-sponsoring this bill with me.
Thank you.
Thank you very much.
Thank you, senators. Appreciate your questions and
Thank you.
And I do recognize Senator Shelly Calvo's request, and I will address it when we hit the floor. Okay? Thank you.
Okay. At this time, I'd also like to recognize that we received the fiscal note from BBMR on April 17, 2025. Legal counsel has reviewed this legislation with no recommendation, changes, or amendments at this time. And lastly, the invitees for this was the Judiciary Guam Public Defender's Office, and of course, across the ocean is the Sixth Amendment Council Corporation. At this time, if there's no further questions or comments, this bill has been heard, Bill 97-38 LS. If there are any written testimonies on today's hearing within 5 business days, please submit that to my office at 238 Archbishop Flores Street, Suite 407 at the DNA Building in Hagatna. You may also send your written testimony to my office email at senatortelot@gmail.com. Thank you all for your participation. Create a great day. And at this time, the time for this bill is ended at 3:40 p.m. We're going to take just a 2-minute recess before we begin our next bill, which is Bill 33-38. Thank you. We're in short recess. Buenas and Hofade, welcome back from our short recess. Again, welcome to the People's House. And I did do the opening statement and clarified the rules of engagement as well as my position and today's date. Again, they were heard, it was mailed out for this public hearing, and then KUAM. So I explained all that earlier. So I'm just going to go right into the next bill, which is Bill number 33-38 COR, an Act to amend 25.15A2 and 25.20A2 of Chapter 25, Title 9, and 715H7 of Chapter 7, Title 1, Guam Code annotated relative to expansions of the elements for first and second degree criminal sexual contact, which is introduced by our Vice Speaker, Tony Ada. And at this time, I would like to recognize the author of the legislation for their opening remarks.
Thank you, Madam Chair. 3338, if enacted, will increase the culpability of certain sex offenders who sexually assault child victims who are 14 and 15 years of age, and applies the strictest penalties for the perpetrators. It expands the list of perpetrators who take advantage of their positions of authority and sexually assault teens who are 14 and 15 years of age. Under Guam law, any person who sexually assaults a teenager who is 14 or 15 years of age commits the crime of third-degree criminal sexual conduct as a second-degree felony. As such, the minimum term of incarceration is 3 years. The term can be as low as 1 for first-time offenders and may even be probation if the perpetrator qualifies under the Justice Safety Valve Act. Under current law, the crime becomes first or second-degree criminal sexual conduct as first-degree felony if the victim and the perpetrator are related by blood or affinity, or members of the same household. Under Guam law, the minimum penalty for first-degree felony is 5 years and 15 years if the felony conviction is for the first-degree criminal sexual conduct. Also, thanks to a law I authored in the 36th Guam legislature, the Justice Safety Valve Act does not apply to first or second-degree criminal sexual conduct. The bill expands the list of perpetrators to include school personnel such as teachers and school aides, child care, or foster care providers, correctional facility workers, and those who are in a dating relationship with a member of the victim's household. The bill also expands the definition of affinity only for criminal sexual conduct to include a person in a dating relationship with one of the victim's parents. Guam's children need the protection of our laws to ensure that their homes are safe and that would-be sex offenders do not abuse their position of authority to victimize their children. I look forward to hearing the testimony today and also from the Attorney General and those who are here today to provide testimony on Bill 33-38. Thank you, Madam Chair.
You're very welcome, Vice Speaker. And just for the record, we received a fiscal waiver from BBMR on January 30th, 2025. Legal counsel has also reviewed this legislation with no recommended changes or amendments at this time. The invitees were offered to Guam Behavioral Wellness Center, Guam Bar Association, Public Defender's Office, Office of Attorney General, and the Guam Coalition Against Sexual Assault and Family Violence. They were invited to this public hearing and to provide testimony. If they're not able to do so, they can do within 5 days after this public hearing. And at this time, I'd like to recognize the first on our list, our good Attorney General of Guam, very hardworking individual, Douglas Moylan. You are recognized.
Hofade Oversight Chairwoman Taitague, Vice Speaker Ada, Senator Calvo, Senator Gumatauta. I would like to, Buenas and Hofade. To my right, I have Christine Tenorio, who's our criminal sexual conduct prosecutor and has extensive experience in both analyzing magistrates, trial prep, as well as having prosecuted many a defendant for criminal sexual conduct crimes ranging from pedophiles to adults, victims. This testimony is submitted on behalf of the AG's office and our client, the people of Guam, in support of the adoption of Bill number 33-38 to expand the elements for first and second degree criminal sexual conduct into Guam law. The proposed amendments, with the exception of the proposed definition of affinity and reference to dating relationship, will mirror current versions of the analogous Michigan criminal sexual conduct statute in sections 750.520B and 750.520C, upon which the Guam criminal sexual conduct statute was based. The AG's office agrees with the addition of the language. The AG's office also agrees that criminal sexual conduct between individuals related via affinity through what other jurisdictions would define as common law should be criminalized. And that seems to be very common on Guam, with people not marrying as much as they used to. However, the proposed definition will cause legal issues because the definition of affinity is a legal construct that cannot be easily translated to dating. The new definition would criminalize sexual misconduct by the girlfriend, boyfriend of the victim's parent, sibling, nephew, grandniece, grandparent, uncle, aunt, first cousin, great-grandparent, great-uncle, aunt, and great-great-grandparent. This would be regardless of the length of time dating. It should be noted that it does not appear that any other jurisdiction has created such an expansive definition. It is not necessary to make this definition applicable to Chapter 25, as family or household member is exhaustive and already includes the proposed affinity definition. So basically, we're just asking for a little bit of a tweak in this the statute per this public hearing. The inclusion of subsection H would suffice to criminalize the individuals with regular access to the victim's households without criminalizing every relationship described above. However, the AG's office would request that subsection H be added to 9 GCA section 25.20 for uniformity purposes. Additionally, the phrase dating relationship should be defined because the AG's office anticipates that this would be an appealable issue. Please be aware that the Criminal Law Review Commission recently proposed the following definition of affinity and consanguinity in 9 GCA section 2510, which the AG's office proposes to tighten up the law and make for easier prosecution. Under the construct, and we provide an actual chart in our written testimony, the affinity defined means, affinity means family members related by marriage. The method of computing degrees of affinity is the same method as computing degrees of consanguinity. And then under the relationship by blood defined, a relationship by blood is defined as a relationship between persons arising by descent from a common ancestor or a relationship by birth rather than by marriage. The degree of consanguinity is determined by counting upward from one of the persons in question to the nearest common ancestor, and then down to the other person, calling it 1 degree for each generation in the ascending as well as the descending line. This is what lawyers have to deal with every day. So, and also the probate code is replete with this as well. Regarding the teacher-student relationship, a similar bill was introduced by Speaker Frank Blas, Jr. in the 36th Guam Legislature under Bill 143-36, which focused on the provision of teacher-student relationships. The following testimony was submitted at that time, and this is quoting the testimony. Guam's current criminal sexual conduct statutes do not include the criminalization of a teacher-student sexual relationship. Guam's first-degree criminal sexual conduct and second-degree criminal sexual conduct statutes are derived from Michigan. The proposed provisions are copied from the Michigan statute. They are the only 2 provisions of the statute not provided for in the Guam statute. The Michigan provisions regarding the teacher-student relationship went into effect 2002. Proponents before the Michigan legislature aptly summarized the need for the bill by stating, parents need to have trust in those who are entrusted with the education of their children, and children should be able to attend school without fear of being lured into a relationship with a teacher or school administrator. Though current law does allow prosecution of those in the position of authority who use that authority to coerce intercourse or sexual conduct, a prosecutor must establish that the teacher is indeed in a position of authority over that student, and that he or she used that authority to force or coerce the sexual activity. The bill would relieve a prosecutor of that burden. This is important because in the case of consensual sex, it is difficult to prove that the teacher or administrator use the power inherent in his or her position to force that relationship. Further, even though the age of consent is 16 years old, it is inappropriate that teachers or administrators engage in liaisons with students. The bill would create a strong deterrent to any teacher or administrator considering such an ill-advised action. Now, other states have enacted statutes focused on this type of educator misconduct. Ohio, Texas, North Carolina, Connecticut, Maine, Nevada, Alaska, Iowa, North Carolina, Georgia, Florida, Maryland, Vermont, and Wisconsin have similar statutes, but with differing grades of offenses. Washington, Louisiana, and Arkansas have similar statutes, but only criminalize the sexual conduct if the student is less than 21 years old. Oklahoma criminalizes the sexual conduct if the student is less than 20 years old. Alabama criminalizes the sexual conduct if the student is less than 19 years old. Arizona, Montana, New Jersey, Kansas, New Mexico, Colorado, Indiana, Kentucky, Mississippi, and Maryland have similar statutes, but only criminalize the sexual conduct if the student is under 18 years old. Now, Wyoming criminalizes the sexual conduct only for elementary and secondary schools. Minnesota criminalizes sexual conduct if the student is less than 18 years old with different grades of offense based on the student's age. And Illinois criminalizes sexual conduct if the student is less than 17 years old. The AG's office supports this legislation to strengthen our criminal sexual conduct laws and to better protect our people of Guam. By passing this legislation, we will send a clear message that Guam will not tolerate the exploitation and abuse of our most vulnerable. And as a note, you know, this office, the AG's office, is very much into the deterrent message. You know, we'd rather deter the crimes than to be prosecuting people, because overall it's just a bad feeling and uses up our taxpayer resources. So it's putting the laws on the books as the Vice Speaker is proposing, but at the same time having an Attorney General's office with people like Christine Tenorio in it, that we can effectively send the message of deterrence to the community by using examples of people we prosecute. So thank you very much for allowing us to comment. And I believe I have Ms. Tenorio, Prosecutor Tenorio here to also field any specific questions.
Yes, I was going to ask, would you like to make a comment? Or?
My name is Christine Tenorio. I'm an Assistant Attorney General. I'm also the Criminal Sexual Conduct Prosecutor on Guam. I joined in Attorney General Moylan's testimony, and I'm available for any questions at the end of the testimony.
Thank you so much, Christine. Good to have you here. And next, we'd like to recognize Jane Flores. You may proceed.
Hafaday, and thank you, Senator Taitague, Speaker Blas, Senators Sean Gumatauto, Shelly, Calvo, and Senator Tony Ada, the author of the bill. The Bureau of Women's Affairs respectfully submits the following testimony in support of Bill 3338. According to the Guam Police Department's Domestic Assault Response Team, in the last 8 years, an average of 72% of the criminal sexual conduct cases filed with GPD have involved victims who were minors. Guam's Healing Heart Crisis Center, which helps victims, survivors of sexual assault, reports that the percentage is nearly even with regard to data showing whether the perpetrator is a family member or an acquaintance. So BWA supports Bill 3338 as a way to ensure that those acquaintances who would commit this heinous crime against a vulnerable child or minor person over whom the perpetrator may have a position of authority or influence do not fall through any legal cracks with regard to punishment when they are convicted. Because every measure helps when it comes to the deterrence of sexual assault, and we clearly have a problem with it on our island. According to the Division of Children's Wellness at the Department of Public Health and Social Services, for fiscal year 2023, drugs and/or alcohol accounted for 57% of the risk factors when children were taken away from their parents because of abuse. In 2020, a woman was sexually assaulted and murdered in Totu by a man who told officers that he had blacked out and couldn't remember details. How many other times have we heard about sexual assaults where the perpetrator was intoxicated or using illicit drugs? While we cannot limit a person's ability to purchase alcoholic beverages if they are 21 or older, BWA suggests that the 38th Guam Legislature might consider providing funding for more awareness efforts about what to do if someone tries to sexually assault a person of any age. The BWA awareness video, Don't Be That Guy, is part of this effort. We also have a federal child youth grant to develop bathroom stall posters, kind of like what you see in international airports in the stalls if you go in, well, in the female bathrooms anyway, that tell young people what they can do if someone is doing something to make them feel bad or harming them in any way. Our other federal grants provide some awareness funding, but not much. The Guam Coalition Against Sexual Assault and Family Violence notes that an increase in the reporting of sexual assaults doesn't necessarily mean there's an increase in these crimes. Instead, it often signals an increase in the number of people aware that they have the power to make the abuse stop. So awareness efforts do work in that they help to empower potential victims, because the more we empower a person, the more opportunity they have to protect themselves against sexual assault and say no. Another suggestion with regard to the acquaintance perpetrator aspect might be to tighten laws to provide for stricter screening for those who work with or near children. Sexual assault is the most underreported crime in nearly every community. So the BWA applauds the authors of Bill 3338 for the convictions and increased punishment that this bill may provide. We do note, however, that this measure alone will not solve the problem. Much, much more needs to be done. Thank you.
You're very welcome, Mrs. Flores. And at this time, I would like to turn over the opening, not just opening, but for questions to the author of the legislation. Vice Speaker Ada, you are recognized.
Thank you, Madam Chair. I'd just like to thank Attorney General Moylan, Attorney Tenorio, and Ms. Flores for their testimonies here today. You know, Ms. Tenorio, your record on prosecution for criminal sexual conduct is truly amazing, and we thank you for your hard work in protecting those who are very vulnerable. And we just hope that by strengthening our laws, and we continue to look for the loopholes and where we can strengthen them to ensure that prosecution on your end becomes one of those that will be able to ensure that justice prevails. And I think, Ms. Flores, you're right. We do need to continuously educate our youth to ensure that, you know, they know that they can turn to someone for help before something happens and not wait until that time. And unfortunately, we don't know when that time is. So educating our community is always very important. Attorney General Moylan, thank you for your testimony and the work that you guys do at the Attorney General's office. You know, the bill dating relationship and the affinity provisions of this bill were worded specifically to exclude the Romeo and Juliet relationships. The amendment to the affinity provisions, is necessary to include boyfriends or girlfriends of the parents and their relatives who are not living in the same household as the victim. So, you know, do you have any other additional comments on that, or, you know, how we can straighten it, or do you think that would be okay how we have it?
I would like to also comment that being in this position, I've been seeing the deterioration of the families, but especially the influence of meth. You know, we've always had alcohol in our community, but alcohol has a certain pattern of how it affects people. But what's going on in our family court system that nobody gets to see except we lawyers and the parties involved is destroying the families, and the change of the behavior, the use of excuses such as the person was drunk and then went into somebody's bed in the household, especially with the cultural differences with the Micronesian community. We hear things, and Christine she's basically the one that relates a lot of these things, where they think it's acceptable at younger ages to engage in intercourse. All that is playing out in the courtrooms as these bills are being introduced, but meth is destroying the families, and this is at a bigger level, not only causing maybe men to be more out of their frames of mind, but influencing the family members that are in that household because they're on a substance that's changing their behavior. So whether you blame them or not, the next generation is being destroyed in every capacity you can think of, in addition to losing parents, to being taken away from them and being put into the family court system, and eventually, and I've seen it time and again, the military coming in here, serving as foster parents, and then adopting our children from parents that can't control their addiction to meth. So, Senator, this is part of that overall prophylactic in sending a deterrence message out, and thank you for having submitted this, and for all the senators for endorsing it.
Thank you, Attorney General Moylan, and thank you guys again for your testimony once again. Madam Chair, that's the only questions that I had. Thank you.
You're very welcome, Vice Speaker Ada. Speaker Blas, you are recognized.
Thank you, Madam Chair, and thank you to the panel. Thank you very much, Attorney General Doug Moylan. For a matter of full disclosure, my daughter, okay, Attorney Christine Tenorio, and my aunt, okay, Jane Flores. You know, I appreciate the testimony, Mr. AG, and you're right. As you were reading your testimony, and you reminded us of a bill that I had introduced back in the 36. You know, the chairwoman and I. Actually, she did some research, and it's unfortunate that, you know, even went back in the 36 that it didn't even receive a public hearing. And in that instant, for that particular reason, there could have been, you know, some cases that may not have occurred, if events that would not have occurred had that been put into statute. This is one of those things I hope will be able to provide that stopgap measure. You know, you're absolutely right, and it's unfortunate that it has to reach the level of, you know, that it has to get as far as going to court. It should have never happened to begin with. And that if there was a way that we can be able to legislate and provide individuals who decide who want to be able, from thinking about wanting to commit this type of offense, the ramifications, the consequences to their actions, it could probably prevent them or deter them from doing these things. And I guess I want to ask the question, I guess, is more so to all due respect, sir. I'm going to ask the attorney that has a resounding success in being able to prosecute this. How would this type of legislation actually help you based on your experience so far?
Thank you, Speaker Blas. So currently, I am allowed to prosecute this type of conduct, but under different theories and under a lower felony. So third-degree felony, the range is 1 to 8 years. This piece of legislation would allow me to prosecute under first-degree criminal sexual conduct where it's 15 to life, because it is these types of relationships within households, within the foster care facilities, and all the other relationships delineated here that it would allow me to prosecute these defendants to the fullest and not let them get away with the sentence that it would be the same sentence as an adult victim. And it's not that adults are, the children that are vulnerable victims. So that is what this piece of legislation would allow us to do. And to kind of also answer what Vice Speaker Ada questioned earlier, the dating relationship is going to help me prosecute. I do think that subsection H is a very important piece of this legislation because it would help me address common law. As you know, common law is not adopted on Guam, so I cannot proceed under that definition under the current law. It's the affinity portion that we're going to have a tough time with, but if the subsection H would allow me to prosecute those relationships that the legislature was concerned about. So to answer the question, it would allow me to prosecute these cases more easily. The reason why AG Moylan read out the computations is that is necessary because those definitions are lacking. And when I have prosecuted these cases, defense attorneys are clever and they are saying, well, the Attorney General cannot tell you how to compute because it's not in the statute, and therefore I'm legally barred from explaining to a jury how to compute method of affinity and consanguinity. And so we put the table in there to show you literally how I have to show the jurors on paper, but it's not codified. So I run into issues when I'm trying to do that. So that's why we appreciate the additions and that the definitions of affinity and consanguinity, those were just spoken about and proposed at our recent Criminal Law Review Commission meeting. That was the commission that was enabled by Speaker Blas for his legislation 2 years ago. So that is the very long-winded answer to your question. It would help me do this more easily because when we get to jury instructions and when we're arguing with the court, they're like, where is the definition? What did the legislature intend? And so by being explicit about what you intended, I'm able to argue that successfully to the Superior Court. And then I'm also the appellate attorney for criminal sexual conduct. So I have to go before the Supreme Court and argue definitions all the time and argue what the legislature intended. And so by more clearly delineating these relationships under this bill, it would enable me to prosecute more easily. There is a section that is currently in the bill that doesn't pass muster. It's the in the current statute. It's the it's in a relationship with has an authoritative relationship and causes that victim to submit. We can proceed with the teacher relationship under that. I've tried. It's a very hard thing to do. So by delineating explicit these relationships without me having to perform legal gymnastics to get there, this would help me greatly.
Thank you very much for that explanation. Not long-winded at all, it was necessary, appreciate it. And I appreciate that this will help to close the gaps and fill the gaps for some of those areas that of concern. And I want to thank the sponsor to allowing me to be able to co-sponsor this as well. And I appreciate your testimony, and you've got my support on this, so thank you very much. Thank you, Madam.
Thank you.
Thank you, Speaker Blas. Before I recognize my other senator for opening up, I'd like to recognize Senator Perez, who's joined us. Thank you, Senator. And I'd like to recognize Senator Gumatautau. You have the floor.
Thank you, Madam Chair, and thank you to the panel for your service to the people of Guam. I just wanted to start with this afternoon. According to statistics made available through the University of Guam's Violence Against Women Prevention Program, Guam has the second highest number of rapes per capita in the United States. There are 64.2 reported rapes per 100,000 people in Guam compared to the national rate of 25.2 per 100,000 people. Sexual violence affects millions of Americans, many here at home, and sexual violence is pervasive among college students, many of the college students that I probably would walk by twice a week when I'm up there at the University of Guam. I just wanted to, if I could, just also bring forward stats, Madam Chair, from our sister branch who was just here from the Judiciary of Guam. In 2023, there were 10 trials for criminal sexual conduct. It was #1 amongst the trials that were reported by the Judiciary. I'm sure it's of the 847 filed felony filings that were done in that branch in 2023. Not much was changed in the year previous. It was actually 3 more of 7 trials in 2022. I bring this out importantly because I just want to say that it is a big problem in this society. According to a media report, and this is very timely, the Archdiocese of Agana is scheduling a series of forums this month in conjunction with Child Abuse Prevention Month, Sexual Assault Awareness Month, and Youth Violence Prevention Month. Acknowledging that the meetings that were conducted recently by the Archdiocese of Agana that were mandated by a federal bankruptcy court settlement, if I can, maybe for the panel, what government or maybe non-government-led initiatives are in place right now to help provide safe spaces for children and families to report alleged criminal sexual conduct including information on the suspicious behavior or actions of individuals which, if not mitigated in a timely manner, could lead to unwanted outcomes. Maybe I can ask maybe Jane or maybe Attorney Force.
We do know that there is supposed to be a Lonnie Kate curriculum within the Department of Education that's supposed to talk about good touch, bad touch with the kids. What we're finding, though, when we meet with people in the Youth Congress, that a lot of their health classes just don't talk about sexual assault. And so this is why we got the federal grant, our child youth grant, to put the in bathroom stalls. And we are going to meet with it's a community effort where we meet with GDOE counselors, DYA, not only the DYA clients, but the DYA counselors and Ojibwe, to decide what kind of language when you put these posters in the bathrooms. And I apologize, I haven't been in the men's bathrooms in places like San Francisco Airport, but those of you who have been in the women's bathrooms, you go in the stall and you shut the door, and there's a poster there that says, "Are you okay?" It has someone taken your passport. Is someone harming you? And so we want to put this language in bathroom posters in the middle schools, in the elementary schools, in the high schools, in the mall bathrooms, just so kids know, explaining, is someone making you feel bad? Is someone touching you in a way that makes you feel bad? Is someone giving you gifts that make you feel uncomfortable? Here's what you can do. Here's who you can call. This is what you can do. And so we're trying to create more awareness. And what we think we can do with these, we have GDOE on our side with these, is to give them to teachers to actually, as a tool to talk to kids about this kind of stuff. Because the more awareness, as the coalition tells us, is the more you're aware, the more you give the kids power to say no. Because as many of us who deal with this know, if the perpetrators look for vulnerable victims that they think are not going to speak up, but if we can teach kids to speak up and say no, leave me alone, it goes a long way toward preventing this crime. But we have Vero, but we really need to engage the kids in the schools, because that's where we teach them.
And if I may add to Ms. Flores, so the Lonnie Kate program, here's the issue with that. It's an excellent program. It teaches kids about good touch, bad touch. It's only confined to elementary, though. And so a lot of the disclosures are coming out later, delayed disclosures when the victims are in middle school or high school. Here's the issue that the Lonnie Kate curriculum does not address. With all of my minor victims, I ask, did you go through the Lonnie Kate curriculum? Did you learn good touch, bad touch? The answer is yes, but the curriculum doesn't teach them how to deal with affecting their family, because I want to say 80% of my cases, it's a familial relationship, which is why this piece of legislation is so important. But they don't teach them what happens after you disclose. They're telling them to disclose, but they're not given therapy services to how to deal with that, or how to deal with the guilt of breaking apart the family, they think it's their fault, they put their father or uncle or stepfather in jail. So I think that is what's missing with that curriculum.
We do, Senator, we do have, through our sexual assault services program, we have grants with West Care and Guam Sarka, where the families, especially in West Care, they do family counseling when something like this happens. But the need is so much greater than the number of counselors that we have, and that's the issue, is that we just need more counselors. We need more bodies to help in this situation.
Thank you so much. And I just have one more question, Madam Chair, and maybe you can help me answer it. I know that you probably, from your experience, you can share with the committee what you've heard or seen, but when we think about the immediate long-term impacts that these criminal sexual conduct cases, their impact on, I guess, learning, and what we think is maybe impact on on other parts of the education process of a young person. Can you help shed some light on that?
Senator, I just want to tell you that every single one of the women who are in the in-unit recovery program at Jibwick was at one time a victim of sexual assault. So tells you a lot about how this affects someone going forward in their entire life.
Right, and to echo that, although every victim is different with the way that they cope, much like people grieve in different ways, there are resilient victims who are strong and they are able to go about their daily life, but the trauma is always with them. There are less resilient victims who every day in and out, this is all they think about was the sexual assault that they've experienced. But as far as the school's concerned, I've seen kids excel despite what has happened to them. I've seen their grades plummet despite what has happened to them. So there's a whole range of demeanor and educational progress and the way they manifest their trauma. There's a whole range of emotions and effects.
But this is the first step. That's why the AG's office, Christine's so important, because the first step in rehabilitation, catharsis, whatever you want to call it, is getting the justice. And I can tell you as an Attorney General, receiving the phone calls from Christine detailing the types of conversations that she's having with these victims, these kids are scarred for life, but how the body responds and adapts to the pain that goes on, and especially from the ones you most trust, your parents, a person that the parent brought into the household. That's the type of stuff we're dealing in the AG's office, and that's why Christine is so important at that office with our team, our other team members. But I mean, she's educating the other prosecutors that we're bringing in to know how to deal with these type of crimes. And I'm the one that takes the calls from the police at first blush, and just hearing what they're going down, and then it gets into the he said, she said, everything that the defendant's rights are. That's what Christine and the team have to deal with every day, senators. So it's a difficult issue. Very few witnesses.
Thank you, AG Moylan, and thank you all for your service. And yeah, I stand with this legislature, and we got to be tougher, and we just got to take care of this really big problem in our community and our society. Thank you, Madam Chair.
You're very welcome, Senator Gumatauta. Senator Calvo, you are recognized.
Sidus Masi, Madam Chair. Half a day in Buenos, everyone. Thank you for your testimonies. As a woman, a mother, this piece of legislation is truly important. Protecting our children is non-negotiable. It's a must. It's a priority. This bill number 33-38, does that. By updating our law to reflect modern realities and long-standing loopholes, we are actually not just protecting our kids, but we are aligning Guam with best practices across the nation and ensuring that no predator can hide behind their job title or proximity to the victim's family. You know, it pains my heart to think about abuse towards women, most especially towards children. And you guys are right about it when you mention that it's not just about the situation that they went through, but it's a long-lasting effect to the person, to the victim. This is like a forever scar, you know? So predators, they have to be, they have to be held liable in the highest account. And I'm for that. Especially individuals in positions of trust and authority, exploiting their position to take advantage of vulnerable individuals. I'm a very motivated co-sponsor of this bill. This bill must pass, and I thank Vice Speaker Ada for putting this out on the table, because this is a truly essential bill for our community. There's so much happening in our community that's not even reported. Not even reported. We all need to be vigilant about this. We need to protect children. We need to protect women. We need to protect vulnerable individuals. On that note, I really don't have a question, but this bill must push through. Thank you. Thank you, Madam Chair. Thank you, everyone, for your testimonies.
You're very welcome, Senator Calvo. Senator Perez, you are recognized.
Thank you, Madam Chair, and good afternoon to the panel. And thank you for all the work that you're doing. We do appreciate that, unfortunately. But I guess I want to go back to the testimony that you provided in regards to clarification of affinity as it relates to dating. And so in the bill, there's a section 3 in the bill. Actually, it should have been section 4, but the last section of the bill. So the language in that last section, do you think it helps to clarify dating versus affinity, or do you think it needs more verbiage?
If I may, thank you for the question, Senator. No, I don't think that this is the correct legal definition to use. And I want to explain where I'm coming from. As the appellate attorney, when I have to defend to the Supreme Court, I have to find a basis for using this language. And so the definitions that we gave, the proposed definitions for affinity, consanguinity, that has already passed legal muster in other jurisdictions. So it is better for the legislature to use language that has already passed muster so that we don't have to reinvent the wheel and litigate something that has already been litigated.
So the reference to dating should be removed from the bill?
Correct. So the recommendation was this: the section 3, that the proposed addition to section 3 would not be used. And in lieu of that would be the definitions of affinity and consanguinity that the AG has proposed. Those are legal definitions from, I believe, Michigan.
Thank you. So I'm one of the co-sponsors of the bill because I believe that we need to, hold those accountable. And I think also most importantly, we need to be preventative too as well. But, we have to hit all sides. I think holistically, we have to address this holistically. I guess the question, a legal question is, when we become descriptive, does leaving out other descriptions make it harder to prosecute?
No, because there are always fallback provisions that I can use. So all of the relationships that are now proposed to be added, I actually can still prosecute those under different theories right now. This just makes it easier because it's more explicit. So it wouldn't be exhaustive, and it wouldn't be the suggesting that if the relationship is not defined or delineated, that then I cannot prosecute other relationships. I can use the subsection for causing the victim to submit by virtue of their authority.
Okay, thank you. I think that is my questions, and so I appreciate it. Thank you, Madam Chair.
You're very welcome, Senator Perez. I really don't have that many questions other than the fact that if this legislation were to go through, would it affect the speed and the efficiency of criminal proceedings moving forward? If this legislation was passed, is it clear-cut for the judicial side to act upon it?
Well, in terms of the process?
Yes.
I agree with the earlier senator's comment. Guam has a problem with sexual predators. It's clear, and there are different cultures, our own culture for that matter. But what Christine is trying to indicate is that the judiciary, when you're dealing with a defendant's rights, a criminal defendant's rights, we all have a right to clarity and specificity in the law. The Supreme Court in the appellate level throws out cases, statutes that are vague or void for vagueness, they call it, when the defendant can't understand what is being prohibited, is a big red flag for the judiciary and lawyers, and is prime for defense attorneys to not only argue that case before a jury to prevent us from proving beyond a reasonable doubt, but get the Supreme Court to potentially throw things out. So what Christine has indicated today is troubleshooting at a high level. If this went to the Supreme Court of Guam, would they throw it out or not? And if she was able to prove it with the jury, could it be proven so that people sitting there would nod their heads and say, yes, this is clearly a violation? That's where Christine is coming from.
That's right. And to add to what AG Moylan said, I actually just wanted to clarify something. Although we agree with the subsection H, which should also be added to 25.20 for uniformity purposes, so I can prosecute under both. 2515 is sexual penetration, 2520 is the sexual touching. The dating relationship actually would have to be defined further. That would be up to the legislature. There are definitions that I have seen, but I already know that this is going to be questioned, and that is the one phrase that I'll run into issues with, because the question would be, what is a dating relationship? The way the family violence treats dating relationships, they have a whole exhaustive list of what constitutes a dating relationship. You know, they say, and it's not really defined as dating relationship, it says this applies to adults who have dated, have had a sexual relationship, all of those. I don't know what definition that this body wants to use, but I can already tell you that the dating relationship needs to be further defined, because is it 1 date, 2 dates, casually dating? Is it people who have intimate relations with each other but are not officially boyfriend and girlfriend? Those issues will come up.
Is there other jurisdictions that have that definition that we need to incorporate?
That is a tricky question. So right now, I actually, in preparation for this, I vetted all the jurisdictions. Nobody actually has this subsection. Mm-hmm. So we would be starting from scratch about what a dating relationship is, but there are, we can pull from other jurisdictions and come up with a definition that we believe would pass muster.
So you would look at other case law, then you would look at other case law that would kind of define it. Then is that how you would do it?
Right. So because right now the Family Violence Code, it defines family or household member, but then it has a whole 12 different ways you could qualify, and none of them actually say dating relationship. It's just descriptive of what relationships would be involved in there. So that is one way that you could address that, is go through the way the family violence statute, 9 GC 30.10, defines the relationships, but I also think we could also find a better
definition.
phrase.
Yeah,
right.
Yes, thank you, Christine. Well, I greatly appreciate you being here. I too would like to be a co-sponsor of this. I think there's 11 co-sponsors on this legislation. I know it has the support it needs to get through. However, you know, it does have some meaning toward how I feel about the situation and the need that what we need to do to have every avenue to cover those areas that have not been addressed, that people get away with certain things because of just a slip through the law, you know, and a loophole in the law. So the more we clarify it, the better it is for us. And I greatly appreciate everyone who's being here to testify on this. And I'd like the Vice Speaker to close, if he may, please.
Yes, just to follow up on, what is the reason, like, why we can't, the dating relationship definition can't apply in the Family Violence Act?
So the Family Violence Act already delineates all of the relationships that would be a family or household member, but they're using the phrase family or household member, and the phrase in subsection H is dating relationship, so it's different.
Okay, just for the clarification there. Yeah.
Thank
you. And again, just like to thank Ms. Flores, Attorney Tenorio, and AG Moylan for coming down and providing your testimony, and most especially for your support of this piece of legislation. I believe that it is truly important for, you know, the protection of the vulnerable again. And hopefully that, I like those posters that you were saying, but hopefully we not just get them in the mall and at schools, but restaurants and everywhere else where, you know, we don't think people would be, but they are, you know, at the clubs and all those places. Because I believe that if we can help just one individual and protect them from a sexual assault or sexual violence, then, you know, I think we we can just add that as well. But thank you for your testimonies again, and I truly appreciate all the hard work you all do. Thank you. Thank you, Madam Chair.
You're very welcome, Vice Speaker. And at this time, there's no further questions or comments. This concludes our discussion on Bill 33-38. My office will continue to accept written testimony on today's hearing with 5 business days from today, which may be mailed to my office at 238 Archbishop Flores Suite 407 at the DNA Building in Hagåtña. You may also send your written testimony to my office via email, senatortellot@gmail.com. Thank you all for your participation and create a great day, and thank you for your patience too. I know you had to wait a little bit longer. We're going to take one minute recess as we switch to the next bill that we're going to be hearing, which I believe is Bill 88-38. We'll take a short 1 minute recess. Thank you so much for that short recess, my colleagues. We are back, and we are now going to be entertaining Bill 88-38 COR, introduced by myself, Telo Taitague, with my co-sponsors as Senator Sabina Perez, Senator Therese Terlaje, Senator Chris Barnett, Senator Shelly, Calvo, and Senator Tony Ada. And this is an act to repeal and reenact Chapter 25, Title 16, Guam Code Annotated, relative to assessing the taxation of vehicle title transfers on the bill of sale only and streamlining the vehicle ownership transfers. Okay. I'd like to open up with my opening remarks regarding Bill 88-38. Hafaday colleagues and members of the public, thank you for joining us on this public hearing today. Bill 88-38 aims to bring long overdue clarity and fairness to the way we handle vehicle title transfers here on Guam. As it currently stands, the Department of Motor Vehicle relies on Kelly Blue Book values to assess taxes on vehicle title transfers. However, these values do not reflect the realities of vehicles' conditions on Guam. The Kelly Blue Book is standardized for vehicles in stateside markets where cars may experience less environmental wear and tear. On Guam, our vehicles face harsher conditions, from constant exposure to salt air, to rough terrain, and uneven and unpaved roads, and extended uses, factors that drastically reduce cars' actual market value. As a result, many residents are taxed on inflated vehicle values that exceed what they actually pay. For an example, A 2008 vehicle with over 180,000 miles may sell for $2,000 in a private transaction. But the Kelley Blue Book may list its value at $4,500, resulting in a significantly high tax burden that doesn't reflect reality. This disproportionately impacts our low and middle income families who are just trying to afford reliable transportation. Bill 88 seeks to fix this by requiring taxes on vehicle title transfers to be assessed solely on the bill of sale. The true price agreed upon between the buyer and the seller. It's a compromise change that promotes fairness, transparency, consistency, and efficiency. This legislation also modernizes the transfer process to make it more accessible, reducing delays and confusion at DMV. But beyond tax fairness, this bill plays a critical role in tackling other urgent problems. The growing crisis of junk and abandoned vehicles on Guam. In 2023, it was reported that from fiscal year 2018 to 2022, over 5,000 abandoned vehicles were removed, with 4,247,085 utilized by the mayor's office for abandoned vehicle removal alone. And in fiscal year 2024, 1,377 junk vehicles were disposed of, racking up a bill for Government of Guam to pay contractors $780,700 for the services. Each abandoned vehicle costs taxpayers to remove and dispose of a significant financial burden that should be addressed. By streamlining and encouraging proper title transfer, Bill 88-38 helps ensure that vehicle ownership records are current and traceable. This accountability is essential in identifying those responsible for abandoned vehicles, abandoned cars, and supporting enforcement actions. It also enables better coordination with recycling programs and further government-led cleanup initiatives. I'm grateful for my co-sponsors who joined me in addressing this support. And I respectfully ask all my colleagues to also support this. There have been also some concerns of counter-fraud issues related to this bill that it may cause. I understand the concerns about whether basing taxation on the bill of sale could open the door to fraud. For example, by individuals underreporting the sale price to avoid paying the proper tax. However, this risk is not unique to Guam, and it is already anticipated and manageable through standard legal administrative safeguards. Despite reliance on Kelley Blue Book values, individuals can still falsify paperwork and commit fraud under current system. Moving to a bill of sale system does not create a new risk. It simply modernizes the process to match the actual transaction. Bill 88 doesn't weaken enforcement. It simply makes taxation fair. Enforced tools exist to deter and punish fraud. Guam law knowingly falsifying a bill sale, affidavit, or tax document is already a criminal offense, punishable by fines and potential prosecution. We cannot allow fear of potential abuse by a small few to justify an unfair system that punishes thousands of honest families every day. Our responsibility is to create policies that are fair and enforce them, not to assume everyone is dishonest. Other jurisdictions have successfully adopted similar systems and assessed vehicle taxes based on declared sale prices, with mechanisms for random audits, verification against fair market values, and penalties for fraud. There is no reason Guam cannot implement the same verification procedures, such as spot checks, secondary reviews, and requirements for bill of sales to be notarized. But fraud concerns must be weighed against the injustice if overtaxing honest citizens. Right now, thousands of law-abiding citizens are taxed based on inflated Kelley Blue Book estimates that do not reflect their actual purchase price, hurting low-income and working-class families the most. We should not maintain a broken system that punishes the many because of fear of the few who might attempt to cheat it. Bill 88 promotes ownership accountability, which is critical for addressing the junk and abandoned vehicle crisis on our island. Encouraging legitimate tax transfers with the fair taxation will result in cleaner island and more complete ownership records, making it easier to track and penalize those who abandon vehicles. The risk of fraud can be managed, but the injustice of our current system is undeniable. Bill 88 provides fairness, accountability, and transparency. And at this time, I'd like to recognize those who have come to testify today. Director Maria Lizama from the Department of Revenue Taxation, thank you so much. We also have Michael Agustin that is here with us, and then we do have Ms. Santos is here as well. If you can introduce yourself, please. Are you here to testify?
Not really. I'm just here for support.
For support?
But I can testify.
Okay.
Yeah. And my name is Michelle Santos, and I'm the acting deputy director, and I'm also the insurance and banking commissioner.
Thank you so much, acting director.
Hi, Carl Espaldon, legal counsel.
Okay, legal counsel. Thank you so much for being here. And at this time, we'd like to hear from the director of Department of Revenue and Taxation. You're now recognized.
Hi, good afternoon, Madam Chair, Vice Speaker Ada, Senator Gumatautau, and Senator Perez. My name is Marie Lizama. I am the Director of the Department of Revenue and Taxation. So this bill seeks to assess, Bill 88-38, seeks to assess the taxation of vehicle title transfers on a notarized bill of sale only and streamlining vehicle ownership transfers. DRT currently uses the Kelley Blue Book value, as you've mentioned, to determine vehicle values. The tool is owned by Kelley Blue Book Company Incorporated, a vehicle valuation and automotive research company. It is a standard guide in automotive trade in determining car value and, quote, provides a fair market range and fair purchase price based on actual transactions of what others are paying for a vehicle and adjusted regularly as market conditions change, unquote. It is used by many entities, including courts, insurance companies, banks, and even car dealerships themselves. We believe that the use of the Kelley Blue Book to determine vehicle valuations for transfer tax purposes is not only industry standard, it constitutes a fair, independent, and third-party standard. DRT is a member of the American Association of Motor Vehicle Administrators, also known as AMVA, a tax-exempt, nonprofit organization that develops model programs in motor vehicle administration, law enforcement, and highway safety. It also serves as an information clearinghouse in these areas and acts as the international spokesman for these interests. AMVA represents the state and provincial officials in the United States and Canada who administer and enforce motor vehicle laws. Its programs encourage uniformity and reciprocity among the states and provinces. The association also serves as a liaison with other levels of government and the private sector. Its development and research activities provide guidelines for more effective public service. We reached out to AMVA for its opinion on assessing valuation of vehicles for purposes of vehicle title transfers. AMVA's Director of Vehicle Programs and Services responded to our inquiry by stating that motor vehicle agencies generally obtain this information through services such as Kelley Blue Book, Black Book, or NADA, which is the National Automobile Dealers Association. ANVA's opinion is that, quote, having the buyer provide the sale price without requiring any evidence to support it causes significant fraud to occur in the titling process, unquote. Part of the bill mentions a correlation between the cost of title transfers and abandoned vehicles. Public Law 37-60 assesses a $1,000 fine to the last registered owner of an abandoned vehicle. We believe this will encourage vehicle transfers to be completed once sales have been made. While the number of vehicles and their values vary over the past 3 fiscal years, over an average of $2.557 million has been collected yearly from an average of 15,000 transactions. Although it is difficult to calculate due to the uncertainty of what vehicle values through self-reported bills of sale may be, the effect on revenue could be substantial. Thank you.
Thank you so much, Maria. Anybody else would like to testify, or they're just here for support?
Basically here for support.
Okay, thank you so much. I will leave my questions for the end and ask my colleagues if they would like to have any questions. Senator or Vice Speaker Tony Ada, do you have any questions?
I don't have any questions at this time. Thank you, Madam Speaker. Thank you.
You're very welcome. Senator Gumatauta, you're recognized.
Thank you, Madam Chair, and thank you again to our friends from Rev Tax for being here this afternoon. I know it's been a pretty long day. If I can, I just wanted to share with the committee that there was a letter that was sent by the Lieutenant Governor of Guam to the co-author of this bill back on May 5th, 2023, relative to another bill that stated that Guam EPA had provided financial assistance to the Mayor's Council of Guam for the successful removal of at least 5,459 vehicles, or an annual average of 1,091 abandoned vehicles each year during the previous 5 years, in this letter back on May 5th, 2023. Understanding that 16 GCA Section 3606C3 provides that if an abandoned vehicle is not claimed after 30 days, it may be auctioned by DRT or sold pursuant to law. When we think about, this is dated almost a couple years ago, when we think about the amount of vehicles that was referenced in the Lieutenant Governor's letter to the co-author, Senator Sabina Perez, when we think about the expenses, including towing, storage costs, how much, is there a round number that the government may take from those kind of claims? This is a lot of vehicles.
So the last amount that we are aware of is it costs $650 per vehicle, far above and beyond what we currently assess or collect for the recycling fee.
All right, thank you, Director. Recognizing that one of the findings from Bill 88-38 COR is that the title transfer costs for Guam residents often prevent them from completing the transfer process, leaving vehicles, for the most part, unaccounted for when abandoned, and ultimately contributing to the growing issue of junk and abandoned vehicles across the island. I don't know if you can answer, but what information is available to validate whether vehicles are being abandoned because of what Bill 88 refers to as excessively high title transfer costs? Or is the reason that most cars are discarded on public property is to avoid paying those scrapyard charges? I don't know, maybe from your experience can share that with the committee?
Yeah, I apologize. We do not collect that information, but we believe that the public law that for abandoned vehicles, the fact that the fine is assessed to the last registered owner, we do believe that that is going to kind of encourage or, perhaps be an incentive for the owner to ensure that the transfer is done.
From the staff, what are you guys hearing out there on the streets about these things?
Senator, we've been meeting with several government agencies on the abandoned vehicle problem. We've been meeting with GPD, EPA, land management, DPW, and that's where we came up with the $650 to take care of the abandoned vehicle. Also, we've also met with the solid waste person. I don't remember his name, but he also says it costs more than what we're charging to ship these. What they do is they take them to a lot and they have a compactor, right? They remove all the fluids, and then they compact them and then put them on a ship. And I believe a Korean firm is buying them. It still costs way too much to do this than what we're charging. So we've been meeting on that, and we're racking our brains to try to figure out how to take care of the abandoned vehicles. They classify them into junk, right, Carl? Junk, and then the ones that are not stripped and can be kind of salvaged and sold. What do they call that? They classify them into two: the junk, where you can't do anything with it anymore, and it's rusty and it's been stripped, and then ones that are fresh, they call it fresh, left within 24 hours. So we've been working with the police, and we're trying to streamline the process where we can even title it to the junk, the tow trucks, so they can sell it to recover their costs. Those are the things we're trying to clean up. Also, trying to work with the mayors on this as well.
Attorney Esperon, were you going to jump in there? You have anything as well?
I guess the only thing that I have to add is being part of these discussions about the abandoned vehicles, abandoned and / junk vehicles, and I think that is going to your question, is I have not yet seen or heard any direct correlation between the inability to pay a vehicle transfer tax and vehicles being abandoned. That might be the case, but I haven't seen any studies, evidence, or even heard about it until now.
All right, thank you for your candor, and thank you, Madam Chair, for the time and the questions. Appreciate it.
You're very welcome, Senator Gumatao. No questions for the speaker. Okay. Senator Perez, you're recognized.
Thank you, Madam Chair, and good afternoon to DRT. Thank you for being here. So just I'm looking over your testimony. It says an average of 2.557 million has been collected yearly from an average of 15,000 transactions. Okay, so do you know what percentage of that is from new vehicle purchases versus transfers?
Senator, those figures are only in regards to new vehicles, used vehicles, not new vehicles. Because new vehicles, there's no fee of transfer on that.
Okay, so these are used vehicles.
Yes, that's only for used vehicles.
I'm cross-checking what was provided by the fiscal note.
Mm-hmm.
So it states that, so in 24, 9.7 million was collected in revenues. However, the revenues generated do not indicate how much amounts specifically represent vehicle ownership transfers. Do you recall the fiscal note? And maybe if you can explain those numbers. I'm assuming those came from DRT.
No, that's the one that's from BBMR, right?
Yes.
I do not.
So, okay, so they developed those figures on their own. Okay. So just trying to, reconcile the numbers that you provided in your testimony with what was provided by BBMR. So they're stating that the registration fees for fiscal year 2024 was 9.7 million.
But are they confusing registration with a transfer fee? That's probably where the disconnect is.
Okay.
And I can certainly go back and just verify that and get back to you.
Okay, so basically you're saying this 2.557 million is transfer fees?
Yes, ma'am.
Okay. Okay, for 15,000 transactions. Okay, so do you know, is there a number, I guess you can't tell me, but is there a number that's not being captured that's not being transferred, the titles are not being transferred at DRT? Do you have an estimated number based on the number of cars that are being imported and how much are sold and that accumulation versus how much is being shipped off island? Do you guys have that?
No.
That kind of information? Because that would probably tell us how much is not going through DRT at this time, right?
Yeah, we wouldn't know.
Okay, so if we're thinking 8,000 cars are sold every year, that's an accumulation of cars. As we know, there's an abundance of abandoned vehicles out there. So yeah, the purpose of this is because that's one of the suggestions in the abandoned car task force. The mayor's actually recommended this to somehow make the title transfer easier because again, there is this understanding or belief that cars are not being transferred to the newest owner. And we hear this testimony over and over again in these task force meetings, the testimonies provided for bills, is that when the police come and they try to find the owner, they go to the registered owner and they say, the registered owner says they sold it years ago. So this is a common understanding that's happening out there. So we're missing a good portion of, we're not capturing, I guess, a good amount of registered owner or owners of the cars that were transferred. And this is one of the purposes of this bill was to increase or capture more or encourage that to happen, encourage that transfer of title to happen. And so I guess, you're saying that the $1,000 fee would help. To what extent, since the passage of that law, to what extent has DRT collected that $1,000? Because I understand from certain mayors that they are using this law.
Yes. Okay. So, with regard to the fee itself, in the discussions that we've had, as the acting deputy has mentioned, part of the discussion includes an educational awareness campaign so that owners or previous owners who have perhaps sold the vehicles to someone else, should, be made aware that there is a fee, $1,000 fee, should that vehicle later be reported as abandoned. It's going to be traced back to them. Now, as part of these discussions, move along, we understand that there's also perhaps just a unclear, or perhaps people are talking about abandoned and junk vehicles as if they were one and the same. So we know that there's a definition for junk versus a definition of abandoned vehicles. And we just feel that we need to go out with an educational campaign on that. Because right now what we are concentrating on in those discussions would be the vehicles that are abandoned. So the junk ones, they've probably been in the jungles or perhaps somewhere else for years. And so, we don't know, as Attorney Espaldon mentioned, we don't know if there is that correlation between, the junk or even the abandoned vehicles and, or the non-payment of the transfer fees to those types of vehicles.
Okay, so again, you know, there is a lapse in regards to ownership, because we're hearing out in the community that when a, say, law enforcement officer tries to find the owner of the car and goes to the registered owner, that registered owner on the books has sold that car many months or so ago. So it does apply to abandoned vehicles. So there is anecdotal evidence to support that. And it's not just a one-time public hearing. It's been several public hearings, including the Abandoned Car Task Force. That's where this idea came up to pursue. How do we streamline the title, the transfer of title, to ensure that we can enforce these, the laws and clean up our streets or our public easements from abandoned vehicles? So I guess the question, you didn't quite answer the question in regards to a $1,000 fine. Has that been implemented?
Oh, I apologize, ma'am, for forgetting about that part. So we just started to implement, we're in the process of actually finalizing the administrative procedure with regard, you know, to that. We have gotten part of that in that so how that happens, of course, is the peace officer determines or identifies the vehicle as abandoned, and then we are informed of that, and then DRT is responsible for publishing the information on our website. And we have yet to iron out the rest of that because, of course, there's been some concerns expressed by the tow truck companies with regards to payment. You know, so we haven't seen yet any collection of the $1,000 fee. And, you know, as I mentioned and Michelle mentioned, that we are continuing our discussions on that. In fact, I think we have a meeting scheduled for May 9, if I'm not mistaken.
Okay. Senator, I'm not sure that that task force is the meeting we're going to. I don't know if there's, because the mayor's office has not been in attendance. We've attended like 3 or 4 meetings and they're not there. So I'm not sure that we're talking about the same meeting, you know, that we're going to.
Yeah, so I think this is when the bill was created. I believe the executive branch did put together an abandoned car vehicle task force. So it may have morphed into something different. So I'm not aware how it changed to. So, okay. So you're thinking that, you're projecting that the $1,000 fine is going to solve the problem of transfers?
We believe that it would highly encourage the owners to ensure that the transfer is done, because I'm sure they would not want to be held or, you know, be responsible for that amount of money or be fined that amount of money.
Okay. As far as proactive measures, though, I mean, there's still room for that in regards to encouraging the transfer of the titles without being hit with a fine.
Yes.
So I think that's what this bill aims to do. So if there's any suggestions that you have to improve the bill, definitely would like to encourage that. I mean, I would like to encourage that as well.
Okay.
Okay, I think those are my questions for now. Thank you.
Thank you, Senator Perez. That being said, you know, it's encouraging. We're finding other avenues to clean up our island with regards to this litter of cars on the side of the road. It causes a safety issue as well. It's very dangerous, even if it's in somebody's yard. I know mayors have been very concerned about that. They're getting calls from their constituents saying that these bunch of cars are in this area, and it's, you know, it's just a hazard, you know, and it's unsafe. So this $1,000 that is potentially, you know, hopefully goes through, you know, with that's good. It's encouraging. But we're still left with the main reason why this bill was created. You know, we've been taxing the people of Guam, overtaxing the people of Guam when it comes to transferring vehicles. For an example, one situation had gone down to Rev Tax to do a transfer of a vehicle they had. Unfortunately, the air conditioner wasn't working. There was a huge dent in the back of the car. The car was assessed in Kelley Blue Book for about $10,000. And then, but nobody from behind the desk where they went to pay for this transfer to someone else would go out and see the car, that the car is obviously not even in fair condition at the lowest amount of the Blue Book, and that they were not selling it at the Kelley Blue Book of $10,000 because the car is not worth it. Now, they've gone to car dealerships and asked for an appraiser, and that's a true appraisal of a vehicle. You take your vehicle to any of these automobile places that sells used vehicles. They take the car, they drive the car, they lift open the hood of the car, they go inside the car and review how much is this worth. Now, when individuals go down to Rev Tax to do a transfer and saying, well, I'm selling this car for not $10,000, I'm selling it for $5,000. They go, well, the Kelley Blue Book says 10, you're going to have to pay 10. But if you go outside and see my vehicle, it's all messed up. I mean, nobody's going to buy this car at $10,000. So you're making me spend $300 to transfer this car to another person. $300 is quite a lot of money. And this has been going on for decades at Department of Revenue and Taxation. People overtaxed for transfer of vehicles that are not worth the Kelley Blue Book. And this has to stop. If we're encouraging people to be responsible, then we shouldn't overtax the people of Guam. If this is going to drop in costs for Rev Tax, well, that should not be an excuse to continue to tax people the wrong way. And that's why we created this legislation. I do understand that this nonprofit organization that you were talking about, American Association of Motor Vehicle Administration, I'd like to read some more about that and exactly what their intentions are. Is their intentions really to assist Rev Tax to make additional revenue for Rev Tax? I can assure you that the people of Guam don't intend to use they already pay their hard-earned tax money for the government to cover roads, schools, and all that the government pays for. But when it comes to being overtaxed, I'm pretty sure the people of Guam are going to stand in opposition for that. So, that being said, I greatly appreciate you taking the time, and I thank you so much for your patience. I know we had my good colleague here has one more question, so of course I'll give her the floor to answer that. Go ahead.
So just to throw it out there, I mean, is it possible to have both in existence, where you have the Kelley Blue Book, and then you can have these, I guess, a bifurcated approach where if the car is really in bad shape, it's not worth the Kelley Blue Book price, that there could be an appraiser situation? Yeah.
If I may, because I had asked that question for my colleagues, there are no certified appraisers at Revenue and Tax, and that's the issue. Now, we can go and get an appraised value of vehicles, but then now what's happening, if you do that, you go to a used car dealership, and you bring the vehicle, and right now it's free. You can go into a used car dealership, ask them, hey, I'd like to sell my car. How much would you like to buy it for? And then they do the appraisal. These guys are very well equipped with the information that's needed. They drive the car. They, like I said, inspect the car. And they give what they feel is fair market. And then that's done. Even if you were to take that to Rev Tax and ask them, look, I got an appraisal for this car from this company here. What's going to happen now is those car companies are going to catch wind of what's going on. Now people are going to the car dealers to get free appraisals, then take their car to Rev Tax so that they can sell their vehicle to someone else. Pretty soon we're going to have these auto dealers or car dealers, used dealerships, charging now appraisals for vehicles. And that's something that we want to avoid as well. But yeah, I did ask that question, Senator Perez, and they are not appraisers. They're not certified, and they could not provide that type of appraisal. Okay. Yeah. And you can go ahead and confirm.
Well, I honestly believe that, you know, with my experience working at DRT under the registration branch, we've seen all kinds of bill of sales coming in. We've seen $1, we've seen $5, we've seen deed of gifts. So how do we charge a transfer tax on top of that? So for what I feel is that we need to develop a system not based on a bill of sale from a seller, because there's no standard in that, what I believe. I mean, if I sell a vehicle to my sister, I'm not going to use a fair market value that we're trying to catch. I mean, I can just sell it for, if I, like say, for example, Speaker Blas sees me post a car for $20,000, and we've known each other. I don't know if you remember, Senator, we used to play for Tumuni. But anyways, he comes to me and says, Mike, I see you posted a car for $20,000, right? Okay, what are you going to give it to me for? We've known each other for a long time. I said, okay, Speaker, I'll say Speaker, but okay, I'll give it to you for $15,000. But there's a catch. I come to your house, I see that nice grill you haven't used 2 times. At the 2 times I've been there, what if I give you a bill of sale for $8,000, but you throw in that grill for me? See, I had an experience in Florida that I'd like to share with you guys. When I first purchased a vehicle back there, I purchased it for $4,000. That was the market value at that time from a used car salesman. He gave me the title, then he gave me the bill of sale, and he said, Mike, although I sold your car for the value of $4,000, I'll give you a bill of sale that states $1,800. At the time, I had no clue all I said was, why would you want to do that? He said, well, because the DMV is going to charge you based on what I put on the on the bill of sale. So, yes, I know you said there's maybe a small number of fraud out there, but who's going to enforce that? What are we going to do when it comes in at $10 or $10, about $20? How do we charge that? I mean, there's a lot of room for people to adjust the actual cost of the car. I mean, if we're only going to say we're going to take it as a bill of sale only, can you imagine what the numbers are going to be when it comes in? We have no clue. There's no standard. So if we're going to phase off the Kelly Blue Book, I just think that they need to come up with some sort of standards, like you mentioned earlier, Senator, maybe an appraisal from a dealership. That maybe makes more sense than for us to accept just a bill of sale determined by the seller that can always name whatever price he wants to name. So that's just my, what I wanted to say is that I just feel that going with a bill of sale determined by the seller, this is not standard. They can make up the price. If you have 3 sellers selling the same car, you think it's going to be the same amount? No, it's not going to be. It's going to be, depends on what they feel they want to sell the car to their sister, their friend, or somebody off the streets. It's not going to be consistent. That's all I'm saying. I mean, there's got to be some sort of standards that we're going to follow, but not just on the bill of sale.
You have to fine tune it because there are a lot of loose ends, like your car appraisers. I mean, who's going to certify them? We even have trouble just with insurance appraisers, them being legit. So you got to fine tune this bill so that we're not left with, having to figure it out or finding other problems. You have to cover all the bases if, this is the way we're going to go.
Thank you. And thank you for those comments, because in situations like this where we're not here making a profit, if I'm selling my car to my daughter and it's the car, well, it's pretty run down, usually it's just given to them for free, actually, to tell you the truth. When you go to transfer, you're already automatically paying $25 upfront. $25 to do a transfer, right? And then on top of that, you're paid 2.5% on the value of it. So it's not like they're not paying something upfront. There's the standard there. Now, if somebody wants to sell their car for parts and not drive it, that's not in the Kelley Blue Book. But if you're talking about fraud, and like I mentioned earlier in my comments, you know, we have laws. We have enforcement for those laws if somebody commits fraud. Those are in place. We can't keep using that as an excuse to continue to overtax our people who don't make a profit usually when you're selling a vehicle. You know, whether they sell it for $10 to somebody else, then the government of Guam will charge them 2.5% of $10. That's fair. They're not making a profit. Now, if you need it to be certified, if they come before Rev and Tax and saying, this is the bill of sale, I'm signing an affidavit, true to form, that I'm selling this vehicle to my daughter for $10. Here's my $25 Rev and Tax that you require, $5 on top of that, according to this, there's $5 on top of that, plus 2.5%. Is there anything wrong with that? Considering, you know, that if they sign an affidavit, it's swearing to that. And if you want to follow up to see if they're, you know, they're committing fraud, then Rev and Tax can do that. There's nothing stopping you.
What about the cost of processing the transfer? We got to make sure we
It's
cover our
also
costs.
$25 up front. And that's fees, actually, by the way, because I oversee the regulatory side at Rev and Tax. Fees that also I know need to go up. They were talking about your fees because it's been at a low rate for so long, and I totally understand that. But you're already paying $25, and $25 is a lot to some people who live on paycheck to paycheck. A lot to somebody who has to sell their vehicle because they can't afford it anymore, or sell their vehicle because they need to pay for their mortgage or need to pay for their rent. You're hitting people like that. You're not hitting the big AK or, you know, Cars Plus people. They're selling brand new vehicles, and they're taxed quite hefty. You're talking about used vehicles. People who are usually in a position of selling their car because of hard times. So I don't see as, you know, that's the whole intention of this legislation. But I do plan on working with you, with Rev and Tax, to see maybe we can come up with a win-win. We've tested every avenue to try and find fairness. Looking at the numbers, of course, you know, we've been overtaxing our constituents, our community for so long. It's time that we adjust that, and that's why this bill is in there. But I look forward to doing a markup meeting, if need be, and we'll ask for any questions. So that being said, if my colleagues don't have any more questions, I will conclude this hearing, and thank you again to the Department of Revenue and Taxation for being here and being so patient, waiting to the very end. That being said, I've concluded this hearing for Bill 88-38, and you can send any testimonies within 5 working days to Senator Telo Senator Telo T@gmail.com. Other than that, we're going to take a 1 minute just to excuse this panel and prepare for the next bill, which is Bill 75-38. Thank you so much. We are back from our short recess. Thank you so much for being patient. We are on the last bill of the evening. Okay, and it's Bill 75-38, introduced by our speaker, Speaker Frank Blas. It's an act to amend 3101B of Chapter 3, Title 16, Guam Code Annotated, relative to exempting non-resident active duty service members and their dependents from driver's licensing requirement. And at this time, I'd like to introduce and have opening our speaker with this bill. You're recognized.
Thank you very much, Madam Chair, and thank you for my colleagues for sticking around. Okay, I know it's late, but also thank you for the panel. For as you come aboard, I'm sure you can introduce yourselves. Bill 75-38 COR. A very simple bill. What it would provide is actually to come better into better compliance with the USERRA codes with regard to service individuals. I want to be politically correct, okay, as well as their spouses and their dependents. And what this bill basically provides is an amendment to what is currently statute. That provides that, first off, an individual who is an active duty member of the military and their dependents be able to provide, to utilize their driver's licenses from their home of record or their state in lieu of being able to have to reapply for a driver's license on Guam. And I know there's going to be some discussion with regards to, you know, what happens if it's expired or what happens if there's our special, as is with our current statutes, driver's license, the different classifications of the driver's license. But I feel that this is, I want to thank first off Mr. Juan Carlos and also Benitez, as well as the military command, Joint Region Marianas and Joint Task Force Micronesia, for basically bringing this to our attention. And I look forward to the conversations and the discussions that we'll have to make this bill a better bill to be able to be brought to the floor. So with that, thank you very much, Madam Chair, for the opportunity to speak, and I look forward to their testimony.
You're very welcome, Speaker Blas. Also, a fiscal note was provided on March 17, 2025. Also, legal counsel has reviewed the legislation with no recommended changes or amendments at this time. Invitations were sent to Department of Revenue Taxation, Office of Veterans Affairs, Juan Carlos Benitez, and the Guam Veterans Commission Chair, Roy Gamboa, to attend this meeting. And at this time, we have in front of us Department of Revenue and Taxation, Maria Lizama, who's here. We also have Matthew Vendrasi. Okay, and then we have, of course, Juan Carlos Benitez, and of course, our director from Guam Veterans is Mr. Joe Agustin. Thank you so much for being here, everyone at the panel. And at this time, we will open up for comments and testimony. Maria, you are recognized.
Thank you, Madam Chair. For Bill, my name is Maria Lizama. I'm the Director of Department of Revenue and Taxation, which oversees the driver's license examination branch. Bill 75-38 COR seeks to exempt non-resident active duty service members and their dependents from Guam driver's licensing requirements if they already possess a valid operator's license from another U.S. jurisdiction. Passage of this bill would remove for these individuals the current requirement either to switch out their out-of-Guam driver's licenses for Guam driver's licenses or to register their out-of-Guam driver's licenses with the department, which would allow them to drive on Guam's highways for up to 1 year. As a result, the removal of this requirement should help to alleviate the workload of the DLEB in switching out or registering out of-Guam licenses and save on manpower hours for the agency. Since DRT currently does not collect driver's license related fees for non-resident active duty service members and their spouses, the fiscal impact is expected to be minimal as it would be limited to other dependents. The bill, however, does raise some concern about the loss of contact information for this group, which DRT currently provides to law enforcement agencies on an as-needed basis in accordance with the Driver's Privacy Protection Act. We also note that under the bill as written, active duty service members and their dependents who have a valid operator's license from another U.S. jurisdiction would not be required to obtain a chauffeur's license in Guam in addition to an operator's license. If this is the intent of the legislation, the department points out that a chauffeur's license is required to operate specialized vehicles and services, including limousines, taxicabs, buses, construction equipment, and other commercial vehicles. To obtain a chauffeur's license in Guam requires an applicant to be at least 18 years old and to pass both written and driving tests. The bill as drafted would ostensibly allow a simple driver's/operator's license from another U.S. jurisdiction to suffice as a chauffeur's license in Guam. And that is our testimony.
Thank you so much, Maria. Lex, I'd like to hear from Juan Carlos. You are recognized.
Thank you. Thank you, Chairman, for inviting us to participate and talk on this legislation. Thank you, Speaker, for introducing the piece of legislation. This is it is wonderful news, and we want to alleviate a concern that has been happening here in Guam with the amount of time that it takes to get driver's license at the revenue and tax, and the economic weight to our local economy. When you look at the amount of military personnel presently stationed in Guam, it's around 10,000 enlisted, plus around 5,000 dependent. When you look at by 2037, we're looking at doubling that population. Those rotations are 2 years and 3-year rotation, depending if you come a company or on a company. So every 2 years, you would be having a massive amount of people having to go to the revenue tax to get the driver's license, which under federal law and present statute, the Gov Guam doesn't collect any revenues from. So it only adds to the wear and tear of the equipment that we have here, and to the lengthy lines that we have to all go through that live here in Guam and consider Guam to be their home. With that, I do have here with me legal counsel and Captain, I don't want to butcher his last name, but he's the JAG for the Air Force, Judge Advocate for the U.S. Air Force here in Guam. So he'll go into the specifics of the legislation. But for me, this does a really good service for Guam in accelerating and facilitating to the community that lives here to get access to their driver's license in a more expedient manner, at the same time that it saves government money to Gov Guam in the ink and the equipment that has to be used to produce all this driver's license regularly every year.
Thank you, Juan Carlos. Captain, please state your name and what branch of government.
Yeah, thank you, Madam Chair. I'm Captain Matthew Von Drossik. I represent the United States Air Force Department. I'm also here kind of speaking on behalf of the Navy Department as well. They asked me to step in. We're all on the same page on this, so we're providing joint testimony. But Madam Chair, we believe this bill is beneficial mutually to both Gov Guam and to our service members here on island. As you are all aware, territorial law requires all drivers to obtain a Guam driver's license within 30 days of arriving. Individuals may drive with a license from another jurisdiction within those 30 days, after which they must obtain a Guam driver's license and surrender their existing one. Violations of this provision is $500. However, unlike most other jurisdictions in the United States, Guam does not exempt service members or their families present due to military orders. So from the perspective of service members, during those first 30 days on island, service members are in a new unit, spouses are searching for jobs, they're looking for housing and trying to establish new daily routines for their families. So taking a day off work or going down to revenue tax to the Department of Motor Vehicles is an added stressor on top of that. Surrendering their home license, they'll have to repeat this process at their next duty station as well when they move in 2 to 3 or 5 years. More importantly, the law weakens connections to their actual home permanent residence. Each move attenuates the links to residency as properties are sold, account addresses change, and documents are redrafted in new jurisdictions. However, that driver's license provides the enduring proof of an individual's intent to return to their permanent residence. Compliance with this law as it is, without this bill, creates future unknown consequences related to voting, taxation, and estate planning. As Mr. Benitez also said, the current law also negatively affects Guam residents. There's approximately, give or take, 22,000 service members and dependents on Guam. And every one of those drivers exchanging their license would increase the workload for the folks at Rev and Tax and Department of Motor Vehicles, consuming government resources and forcing Guam residents to wait in longer service lines as well. There's no benefits to offset these costs, because when one is surrendering that license, there's no vision exam, driving test, or verification of driver's abilities because they're surrendering a current license. Additionally, in 2023, the Department of Rev and Tax suspended the collection of fees to comply with the Service Members Civil Relief Act. Although the fiscal note for this bill states that the impact is unknown due to the lack of available data, licenses are produced and issued entirely at Guam's expense in time, money, and resources. We'd also say, Madam Chair, that it's not lost on us that historically service members are not made to comply with this provision, and Guam Police Department has not made enforcing that against service members a high priority. We appreciate that. However, as the military population grows, we do not believe that maintaining the status quo would be appropriate. Service members and their families strive to be good neighbors here on the island. We expect and demand that they respect Guam's people, Guam's environment, and Guam's culture. Inherent in that expectation is a respect for territorial law. Aligning Guam's licensing laws with other jurisdictions will facilitate this compliance and reduce the cost to Guam's residents. We also understand the need to generate revenue and maintain Guam's roads that service members and their dependents also drive on daily. However, spouses' driver's licenses, which make up the majority of what we're addressing here, the spouses and dependents, is already not generating revenue because that's been waived. It's costing it. So further, regardless of this bill, the majority of service members' vehicles are registered here on Guam, providing that source of revenue. And lastly, the DoD contributes hundreds of millions of dollars to Guam's roads as part of the Defense Access Roads program. It's fair to expect that service members and their families contribute to the care and maintenance of the roads we also use. We believe that regardless of this bill, we have done so and we will continue to do so. In conclusion, we feel that the prompt passage of Bill 75-38, eliminating the requirement for service members and their dependents to obtain Guam driver's licenses, provided that they maintain a valid license from another U.S. state or territory, will be beneficial to military families, the government of Guam, and Guam's residents. The bill makes good fiscal sense, and it extends the same treatment of service members and their families here that the sons and daughters of Guam serving in the armed forces at any other installation in the United States would receive there. We sincerely appreciate the opportunity to provide our perspective and welcome further collaboration on this issue. Thank you, ma'am.
You're very welcome, Captain. If you can, please, I have a copy of your testimony. However, it doesn't have your name on it or anything to indicate it.
Sure, we can get that to you, ma'am.
Yeah, and probably just work with my staff to get your email and then send it to me, and then we'll incorporate it with your name on it so that we know who this testimony is coming from.
Yes, ma'am, certainly.
Sure. I appreciate your time. Thank you. And Director San Agustin, you are recognized, sir. Would you like to testify?
Madam Speaker, yes, good afternoon. Speaker Blas, Vice Speaker Ada, and Honorable Senator Sean Gumatauto. I am here this afternoon in support of this bill. I, first of all, the Director of the Guam Office of Veterans Affairs, and as you all know, I'm a retired military of 30 years. I always and will always support our veterans and our active duty personnel and their family. The spirit and the intent of this bill, I'm in full support. I want to make clear though that the bill, when it becomes law, it provides protection for the island and the people that live here, but also protection for the active duty personnel and their family. These are active duty personnel that are given orders from all different states and territories to be stationed here in Guam. I would like the members here to be very mindful that these individuals are service members and family members that are here protecting our community, protecting our island. I like the idea of ensuring that they can maintain their state driver's license. But I will also say this, that it now becomes the responsibility of the gate guard and their organization, unit commanders, to make sure that those driver's licenses are valid. So how do they do that? As they're entering the gate and as they're exiting. Because definitely we won't be doing it now, right? We're allowing them to be able to go online and renew their own driver's license. So in good faith, I support this bill to allow the service member, active duty service member and their dependents for the waiver of their driver's license and to maintain their state driver's license. And if any, that we must implement our own driver's license requirement, I will say this, that those fees will be waived as well. These individuals, like I said, were assigned here on duty. They're here for 1, 2, 3, 4, 5 years. Some of them are here because they want to be here. Some of them, they receive orders and they have to execute. So us as good citizens, good residents of Guam, we look after our active duty service members and their families and make sure that we do due diligence to take good care of them as well. They mentioned about paving the road. They mentioned about revenue generating. At least we could do is the fee will be waived, no charge, because daily they go to our supermarkets, they go to our restaurant, and do generate revenues from there. So with that said, Madam, I thank you for this bill. I look forward to this bill being both advantageous for our community and our active duty personnel. And these are our future veterans. I thank you very much for allowing me to speak. Thank you.
You're very welcome, Director. It's always good to see you. At this time, I'd like to recognize, if there's no one else, I think we covered everybody. Marie, your team is good? Okay. At this time, I'd like to open up for the speaker to open with his questions.
Thank you very much, Madam Chair. Thank you very much for the testimony. And while it may seem like there's an impasse, I think that right now amongst us here, I think we can find a happy medium and to address some of the concerns that you have as long as address the concerns that we all have here. You know, in looking at the statute and everything, it basically calls to replace the verbiage that says a person employed by or in the service of the United States while operating a vehicle owned or controlled by the United States need not obtain a operator's or chauffeur's license. And actually there's later statute that directly addresses military service personnel. And I get the concern here is as was pointed out, Mr. Zama, one of the concerns that you had here is with regards to the difference between the operator and the chauffeur's license. I don't think that the intent of the law basically wanted to lump both of them in at the same time. It is very specific here that an operator or chauffeur's license, which means, you know, to operate a car, you need an operator's license, but to operate a bus, you better have a chauffeur's license. And I think that's pretty much evident anywhere. So I think, would it help, first off, if the language was tightened to provide that if it is in fact a chauffeur's license, you have to have an equivalent to a chauffeur's license from the area of, you know, the other jurisdiction of where the license came from? Yeah, okay. So that's an easy add to this. Are you in agreement with that?
We're in agreement.
Okay. See, one issue's off, okay? I think another issue that we're able to address here is the area, and I agree. Now, you remember, coming from a law enforcement background, and I appreciate and I see the value. And as Mr. San Agustin had basically alluded to it and said, you know, I mean, I'm sure that within the commands you have some command and control with regards to who's able to drive on your bases in your installations and what kind of license they have. Is that correct?
That's correct, Mr. Speaker. Yes.
Is there a possibility of being able to work with the Department of Revenue and Taxation and share that information so that they have that in their database?
Certainly, sir. Yes.
Will that help to satisfy that? Problem solved. Problem solved. Yeah. Okay, so I think there are ways to be able to, and I appreciate the concerns that were brought, and being able to marry the two so that we can come to some resolution and being able to address the concerns that you have there. I agree, and I'm sure that everybody agrees here. Because, you know, other than, you know, your operator's license and your chauffeur's license, you know, there's people like, I have a motorcycle license, and we want to make sure that the individuals who are operating, you know, the vehicles have the proper training and license to be able to operate that. Am I correct, Mrs. Law?
Yes, you are.
Okay, so if we can get to that so that we be specific, that if, you know, just because you have an out-of-state driver's license doesn't give you the ability, it's not a carte blanche to be able to operate any type of vehicle you want to be able to operate as well. Okay, so will that help to satisfy the concerns that you have?
Yes, it will.
Thank you. Okay, thank you very much, Madam Chair.
Thank you so much, Speaker. I do have a question, though. When in regards to if it expires, a service member expires, their license expires, they would have to go through the process to renew it on Guam, correct?
Certainly, Madam Chair, everyone has to have a valid current driver's license, wherever that may come from. Okay. They may not let that expire.
Okay. So, and they would have to go to Revenue Tax and follow the procedures?
Yes, ma'am.
Okay. Okay. Vice Speaker Tony Ada, you're recognized.
Yeah, perhaps the only question I would have is, when we say dependent, are we talking about the spouse or the children as well?
So, Senator, although the bill kind of differentiates between a spouse and a dependent, looking at it for the military, those are both the same thing, but the bill does clarify that it will cover both spouses and a dependent of a person who is on active duty.
Yeah, I understand, because it says dependent spouse or dependent children, right? So are we including dependent children as well on this piece of legislation?
Yes, sir. That is included in the bill as is.
Okay. So even dependent children, their fees are waived from this?
Under current law, dependent children fees are not waived.
Thank you. That's what I wanted to. That's why I wanted to clarify when we say dependent, are we saying dependent spouse or dependent children, or are we just making it one? Because if the dependent children are not covered on the waiver of fees, and it's just the spouse, then are we going to keep to that, or are we going to include the dependent children as well?
I think with respect to fees, I think there would not be any fees anymore assessed to anybody. You know, what would happen in respect to fees, I think what the director was talking about, we would lose or we would forego any fees that we would normally charge to dependent children. Because right now we're not charging fees, driver's license fees to the active duty military member or their spouses because of law. And so I guess if they can use their driver's licenses from other jurisdictions, they're not even going to come into DRT anymore from what we understand. And so that we won't be assessing any fees.
Okay, because, you know, Guam, we have our graduated driver's license, right? So if they have a driver's license in a different state that still requires our graduated, I mean, that's why I'm saying, how are we gonna, do we just reciprocate completely and just, that's
correct. For the graduated process, my name is Art Meadow, I'm the supervisor for driver license. What it is if a minor comes in with the only license that we can switch out to pick up a Guam license will be a full operator license.
Right.
Let's say they come in and they're still going through the graduate process, they will not honor that. They will have to go with the locals with the graduate process. They need to see the local driving approved schools and go through that process.
Yeah. Okay, that's why I just wanted for clarification, right? Just so that we're very clear what we're doing, so that there's no misunderstandings in if a GPD officer pulls over a military dependent and there's no questions as to the legality of their driver's license from out of state and things of that nature. But, okay.
And Vice Speaker, if I may, so we just wanted to point of clarification that this is assuming the dependent already has a driver's license from another jurisdiction.
Right.
If they don't have one, they're going to have to go through that process, as Mr. Meno mentioned.
Right. Okay.
Go through the process here in Guam.
Okay, that's great. Okay, that's the only question I had. Thank you. Thank you, Madam Chair.
You're very welcome, Vice Speaker. Senator Gumatauta, you're recognized.
Thank you, Madam Chair. And first off, thank you to Director San Agustin for being with us, and Reverend Tax's team. Appreciate you. Juan Carlos, it's always good to see you. And Captain, thank you for your service to our country. I only have one question, and I'm not sure, this might be a little bit different, but it's kind of a continuation of our conversation a bit earlier. But for the record, if Bill 75-38 COR is enacted as drafted, what implications, if any, does the policy proposal have on the portability of registration documents and insurance policies for vehicles that are brought into Guam and are operated by the same individuals whose driver's licenses would be covered by this bill?
So, Senator, I'll let Reverend Tax kind of speak to that, but generally speaking, we see this as a vehicle would still have to be properly insured and insurance that is valid in Guam. And in terms of vehicle registration, they would have to have the proper registration here in the territory of Guam on the vehicle.
They're not covered by the Service Members Civil Relief Act or for vehicles, no?
So, Senator, when they bring a car here, they're exempted, but once that registration on that car expires, they would have to then renew it here within the territory or renew it within their home state.
No, I'm sorry. We don't have, I mean, do we have information? No. Yeah. Not for, oh, he's here. I'm sorry. Can you repeat the question so we can have Mr. San Agustin answer that properly?
No problem. I'm just looking at it. It's just about the portability of registration documents and insurance policies for vehicles that are brought into Guam and are operated by the person or the operator whose driver's license will be covered under this.
It shouldn't make a difference as far as the Soldiers and Sailors Civil Relief Act, which basically, if a service member's car, if he comes from, like, say, Hawaii, his last duty station, and the vehicle is still current until, let's take example, next year, he can register that vehicle under the the Soldiers and Sailors Civil Relief Act, meaning that the government will not charge them any fees because they already had paid those fees in Hawaii. Under that act, they are allowed, but they must register the vehicle in Guam. They must register it, and what we do is once they meet all the requirements, we provide them a sticker, a Soldiers and Sailors Relief Act sticker. That sticker is to be placed on the front windshield of the driver's side of the vehicle. We give them a Guam registration to accompany the state registration. So in the event they get pulled over, local law enforcement, they'll look at the sticker and know that the vehicle is registered in Guam under the Civil Service Relief Act. But that does not, that has no impact in this bill as far as the driver's license is concerned?
Yeah, that's what I was asking.
Yeah, it doesn't,
I guess for me, what I'm trying to avoid is we make the change, and if there's any issues that might come up, we're going to have to come back here and make a change again.
I believe it won't affect as far as the vehicle registration is concerned.
Yeah, that was my only question,
Yeah.
just in case of any conflict.
Yeah.
Thank you, Madam Chair, for allowing me to ask the question. Appreciate it.
You're very welcome. Just running on that question, but once it expires, so he comes from Hawaii, right?
Yeah.
And the registration that he got in Hawaii doesn't
Right.
expire for another 6 months.
Right.
Then he's obligated to go to Rev and Tax and pay a registration fee
Yes.
and follow through with that, correct?
Yes, so the
Okay.
Relief Act allows them to use the current registration until it expires.
Mhm.
Now, when it expires, he has two options. Either he registered in his state of residence, or he has to switch to Guam. So that will be the choice of the serviceman.
So he has a choice?
Yes.
Okay.
But he has to provide, he has to provide us with the registration from his state of residence. Has to be
Exactly.
active prior to him coming to our
But of
office.
course, we want them to
Yeah.
register on Guam
Yeah,
so we can collect the...
Yeah, majority of them will switch over to Guam.
Okay.
All right.
Okay. Well, I really don't have any questions. You know, I've looked at this actually in the 35th Guam legislature when it was brought to my attention about this, and we were still tweaking some areas of it. But I appreciate you continuing to find ways to help our servicemen here, those who protect our island and keep our island safe. I greatly appreciate it. And of course, with our veterans too, we do everything we can to ensure that we thank them for all that they do for our island and for our country. And I appreciate everyone who's here to testify this afternoon, and I would like the speaker to close on this legislation.
Thank you very much, Madam Chair. Thank you very much for all that here. I think that we were able to resolve some of the major issues. But I just need to be able to, let's nail down a concern that was brought on by the Vice Speaker here with regards to graduated driver's licenses and with dependent children, you know, who, first off, that would be very rare that you're going to have a dependent child get a driver's license or have a driver's license. But in the case that they do get the driver's license and it is graduated and it's a graduated type system, this does not preclude, just so that you know, it does not preclude that if the dependent child now is of the age of receiving the driver's license, before they can drive, they got to get a Guam driver's license while they're here. Okay? I just want to make that very, very clear. This does not preclude or doesn't exclude them from being able to get it. Even if it's a graduated driver's license from out of state or another jurisdiction, that is not generally recognized on Guam. Okay? It is the full-blown, you can drive by yourself or all alone driver's license that we're talking about. Is that the understanding?
That is our understanding.
Okay. That's your satisfaction?
Yes.
Problem solved. Thank you very much. Thank you, Madam Chair.
You're very welcome, Speaker. If there are no further questions or comments, this concludes our discussion on Bill 75-38, as well as all the other bills we heard today as 97-38, 33-38, and 88-38. My office will continue to accept written testimony on today's hearing within 5 business days from today, which may be mailed to my office at 238 Archbishop Fleur Street, Suite 407 of the DNA building in Hagåtña. You may also send written testimonies to my office via senatortellot@gmail.com. Thank you for all your participation. Those who are watching, good evening, have a good dinner, and create a great evening. The time now is 6:02 p.m. Thank you. We are adjourned.
Thank you.